Good morning, Mr. Bowen.
Morning, Mr. Barriel. You well?
I'm good, thank you, sir.
Recording in progress. Honorable members, good morning, and good morning to colleagues from the Parliament team. I see there's somebody from PMG. And good morning to our witness, Mr. Barriel. I want to make sure that I pronounce your surname correctly. So welcome to you, sir.
Thank you, Chair. And good morning to you and the honorable members too. Thank you.
All right, good morning. Thank you. Do you mind switching on your camera? I think you and I have that unfortunate responsibility to to always be visible. You're on mute.
Thank you, Chair. I hope I'm visible and audible.
You are visible and audible. So if you can just tilt your camera a little bit. You know, Parliament has got that Parliament TV has got that strip at the bottom. So once they put it on, people are only going to see your forehead.
Okay. Is that better?
That's better. Yeah, that's better. That's
Sure,
better.
Chair.
No, thank you very much. Firstly, I want to thank you for agreeing to assist us in this process. This is not a trial at all. This is a fact-finding mission. Our interest is to make sure that we can assist the Ministry of Transport, the Board of the Road Accident Fund, and the Road Accident Fund itself to become a better organization. We don't work at the Road Accident Fund and never have. So it's very difficult to make judgments about an institution that appears to be in trouble from a distance. And that is why we have decided to embark on this process. Where someone is not, we understand firstly that some of the matters occurred years ago. So it really is okay to, if you can't remember something specifically, that we assist you to secure that information, or at least you tell us where at the Road Accident Fund it can be found. And then we can ask for that documentation so that it can be useful to us. The second thing I want to say is that matters are not within your personal knowledge, you can specifically say so. Otherwise, you don't need to explain things that fall outside your personal knowledge or expertise. Of course, if you were in a meeting, you were copied on emails, etc., you can speak about that, but just explain the extent of your involvement so that your answers can be understood in context as well, so that we're not unfair to you by asking you questions that you might not be able to give us good answers on. Otherwise, feel free. Let's keep it simple in terms of language. I may stop you from time to time and ask you to explain an acronym or something, or a terminology. That's also because we want members of the public to be able to follow and understand what it is that we're talking about. So you have been speaking to Ms. Ibrahim. So she's a legal advisor to Parliament as a whole. So she's going to explain the rules to you and then swear you in or administer an oath of affirmation, depending on your choice. And then you and I shall have an introductory conversation in the beginning, and then we'll take things from there with the other members, also getting about 15 to 20 minutes to have a conversation with you. We will take a break so that, because you're on the stand the whole time, just so you can get some water, coffee, take a body break, and then we resume, and hopefully we'll finish before lunch, if that's okay.
Thank you so much, Chair. Noted.
No, thank you very much. Ms. Ibrahim, over to you.
Thank you, Chairperson, and good morning to yourself and everybody else on the platform. Good morning, Mr. Barriel. Can you hear me clearly?
Yes, clearly. Good morning to you too.
Okay, Thank you. Sir, you've been invited subject to the provisions of Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act of 2004, laid together with National Assembly Rule 168, which provides certain privileges to witnesses, to appear before the Standing Committee on Public Accounts in respect of the committee's oversight inquiry into the Road Accident Fund. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to civil or criminal proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware further that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or to imprisonment for a period not exceeding 2 years. Mr. Barriel, you had indicated to me that your preference is to take an oath. If I can please ask you to raise your right hand and repeat after me. I swear.
I swear
That the evidence I shall give shall be the truth, the whole truth, and nothing but the truth. So help me God. Thank you, sir. You're now duly sworn in for the duration of the proceedings.
Thank you so much.
Thank you very much. So let's just do an introduction, if that's okay. Can you just tell the committee when you joined the Road Accident Fund, what your different roles were over the years and your last role? And I understand you're no longer with the Road Accident Fund, and just tell us when you left the Road Accident Fund. That's also so that we can scope out all of us, the area that we need to cover and not go outside it.
Thank you, Chair. Again, good morning, Chair and honourable members. My name is Ian Barriel. I was employed at the RAF from October 2010 to March 2024. My previous roles included that of Senior Manager Organizational Development on a permanent role. I was then appointed in 2016 as the General Manager Organizational Effectiveness on a 5-year contract. Basically responsible for the functions of organizational development, design, employee relations, and training and development. My contract was for a 5-year period, as I said, coming to the end on the 31st of August 2023. However, the contract was extended by 24 months from August 2021 to the 31st of August 2023, and a further extension of 6 months from the 31st of August 2023 to the 28th of February 2024 for a further 6 months. During that period, Chair, from a substantive position as General Manager Organizational Effectiveness, I started to act as the Chief Human Capital Officer, appointed and in acting capacity from 1st of April 2020 to June 2022. Basically being responsible and overseeing the entire human capital value chain within the Road Accident Fund. Subsequent to that, I was then appointed as the acting Chief Corporate Support Officer from June 2022 to March 2024. Areas of responsibility included human resources, communication and marketing, and management committees. Chair, that is the introduction from my side. Thank you so much.
No, thank you very much. When did you part ways with the Road Accident Fund?
On the 28th of February 2024. So basically, my contract came to this.
Or at the end of the month.
End of February 2024.
Okay, all right. Thank you very much. Can you just tell us about the process of extending contracts? We had another witness earlier on saying their contract was extended, and some of the members had wanted to know how that worked. And this is just for our knowledge, given your previous role at the Road Accident Fund.
So, Chair, we had
How does it normally work? So we're not asking about you. How does it work in general?
in general, Chair, what was in the policy and our framework was that the executive would do a motivation to the CEO, and in turn, the CEO will notify the board of any prospective extension of a contract, especially at a general manager level, based on criteria such as performance and the critical and strategic nature of the particular role. The CEO would then, in his discretion and based on an evaluation of the factors, as I previously mentioned, make a determination of the extension of the contract in consultation with the board. And that was at a general manager level for 5-year contracts.
All right.
Thank you, Chair.
Thank you. So it was not an arbitrary thing where somebody would just be extended and others not. There was a structured process that leads to an extension of contract with oversight by both the chief executive and the board in the case of general managers.
That is correct, Chair.
All right. No, thank you very much. Mr. Barriel, were you involved in the PwC process in as far as them assisting in thinking through the kind of the redesign or restructuring of the road accident fund?
Yes, indeed, I was, Chair.
Can you just share with us? Were you the sponsor?
Yes, Chair. It was driven from a human capital perspective, the organizational restructure, and we worked with PwC around the design and development of the conceptual model, the functional structure, the leadership structure and management structure, as well as the microstructure. So we did contract in PwC, Chair, to design a fit-for-purpose structure, to conduct a work study, that is a capacity modeling, to co-design the operating model, to conduct a skills assessment, and then creating the costing the structure, as well as the macro structure and the microstructure, inclusive of job descriptions. So that was a process that was the scope of the work with PwC.
Right. So basically, they would assist you in the thinking and strategizing process, but not the implementation. That would be left up to the board and management.
Quite correct, Chair. So there was a conceptual model developed. There was a macro structure developed, a microstructure developed with the associated costing, as well as the skills development. The implementation, we felt very strongly that we needed to own the implementation of the particular process, and inclusive of the change management that goes with the implementation of the structure review.
Right. No, thanks, Mr. Barriel. Tell me, were you also in the conversation about the panel of attorneys and how then the litigation function would then be capacitated in terms of human capital?
Yeah, not directly. I was not directly involved in the decision around the panel of attorneys. That fell within the purview of the CEO, And what we then had was a panel management unit and the exco at that particular time. So, Chair, I was not directly involved in the decision around the panel of attorneys. Thank you.
Right. No, in fact, to be fair to you, my question to you is fairly narrow, and that maybe I should ask it this way. Let me preface it this way, that the decision itself, I think, of which litigation model to follow is in the discretion of the board and management. So that's not what we're concerned with right now. There is an expectation, though, that given that when you got external suppliers, you effectively have warm bodies outside working for you, and you now want to apply a different model, there's supposed to be a transitional human capital plan to say we've got X hundred people outside. It's going to take us X amount to effectively replace them without any disruption. And these are the steps you're going to need to make sure that nothing falls between the cracks and so on. And my estimation, because we had, I keep forgetting his name, Brian, we had one of your ex-colleagues who manages a state attorney's panel saying they still don't have enough lawyers. What we're concerned with as the committee is the cost implication of not being able to defend matters. Hence our interest in the human capital plan that would make sure that the road accident fund does not go unrepresented. So my question to you is fairly narrow in that sense, and that is, are you aware if there was a plan constructed to make sure that the capacitation matches the de-escalation of the use of external attorneys?
Yeah, in all fairness, thank you for that question. I don't think there was a adequate transition plan developed with the panel of attorneys. The state attorney model only came about subsequent, in my view, to the panel of attorneys contract being cancelled, and that is where we started. With the Solicitor General to via the office of the CEO and the CEO himself to implement the state attorney model, and we only started with recruitment either when the contract was about to end or did end, to insource the state attorneys that had a right of appearance in both the magistrate and high court. So in my view, there was not an adequate transition plan developed at that stage, Chair. Thank you.
Right. Okay. No, that's what it appeared from a distance, because the witness we had came in after the fact. So we also couldn't ask him now what the discussion or, what his observations were around the time the decision had just been taken. Can you just tell us whether there was any relationship between the ICMS project, Integrated Claims Management System project, and the Section 189 process and the restructuring? Was there any relationship between the two, and how, whether it would then influence the structure of the road accident fund, and also assist us with whether were there any timelines in terms of both ICMS and then the restructuring itself, and how the two would talk to each other?
Yeah, I would approach your question from a organizational structure review perspective.
Please, yeah.
Indeed, the ICMS, the Integrated Claims Management System, had a huge impact on the organizational structure review and a fit-for-purpose structure, as well as the number of employees that would be that from the current to the future structure. So much of the ICMS in the organizational structure the integrated claims management system, if you look at where we wanted to be with the transformation of the RAF, played an integral role in terms of the determination, and it was one of the assumptions that around which the conceptual model and the functional structure was developed, that your integrated claim system would play a key and critical role in terms of automation, in terms of digitization of the claims processes, and streamline the claims processes. So it was a huge dependency in terms of the success of the transformation. So indeed, there was a close link between the organizational structure review as well as the integrated claims management system from a technology digitization perspective, Chair. Thank you.
Right. So let me share my observation as an outsider, and I need you to correct me if I'm wrong. Right. And that observation is this, that the necessary synchronization in time between the implementation of ICMS and when it would be ready versus the implementation of the organizational change itself did not match, such that ICMS is still not ready. It's multiple delayed. The Section 189 has long kicked off. Would that be correct? And if it's not, please disabuse me and say why.
That assumption would be correct. There was a disjunction. We embarked on the organizational structure review, and the transition and transformation thereof was a journey. But the implementation of your integrated claims management system was a critical component of that, as I've alluded to previously. There was a disjuncture, Chair, in terms of the readiness of such a system that would facilitate the implementation of the organizational structure review. So you are correct in that assumption and assertion, Chair.
All right. No, thank you very much. I've got two more questions, and then my colleagues will come in as well. Can you just explain to us, in fact, let me be fair to you and repeat the claim before the committee. And that claim was that, and these are people who were managers. So because this was on public record, Ms. Christina Mtetwa, for instance, came and said that the process of taking disciplinary action at the Road Accident Fund was at times not initiated by the manager themselves. That is their immediate superior. ER would do it and the manager would get told to do it. So Macintosh Polela, in the case of Hlani Mate, for instance, he had not taken a decision to pursue disciplinary action, came in from ER. And it's less about the specific cases, Mr. Barriel, it's more about the process, because I'm coming to question 2, right? So that's one example. Ms. Christina Mtetwa effectively came and said the same thing. There have been instances where we've asked for a list of suspended employees. Some of them have been suspended for a very long time, and the cases are still within the Road Accident Fund, not even CCMA yet, and so on, which makes one think, okay, if you suspended the person, why does it take so long to put charges to them and then take them through the process and that kind of thing? So that's what we've been told. I'm now asking you to just explain from your perspective how the process is actually supposed to work. If the manager of the employee hasn't taken a decision, or at least had a conversation about charging them, how does somebody who sits somewhere else come and say, charge this person? And then in some cases, the reasons for the suspension are different to the charge sheet that is eventually served. And then it takes years before anything is done. So that's what we've observed, but I need you to just explain to the committee how this was supposed to work. And if you know about such incidents, how does that fall within the rules?
Yeah, thank you for the question. Chair, in terms of the practice and process that normally followed is that the manager would assess any misconduct from an employee. The manager would then call in employee relations to say these are the misconduct of the employee, may it be a financial misconduct, may it be a misconduct of incidences like insolence or insubordination. The ER manager, senior manager, would then assess the veracity of the particular matter, and then move forward in conjunction with the manager to prepare charges for the particular employee. And that would be signed off by the senior manager, ER, and the manager. And then we would proceed by presenting the charges to the employee. A disciplinary, might be internal disciplinary, formal disciplinary hearing would ensue. And if there's an outcome, then the employee has the right to take it to the outside authorities to deal with the particular matter. Chair, it is true that in some instances where there was a perceived misconduct by an employee, that there may have been an instruction from an executive or the CEO to highlight the misconduct and then to request the manager to take the necessary steps against the employee. So I am aware of such the general matters that may have occurred in terms of the misconduct and or the instruction being received from outside the realm of the ER or the manager. It is not true, Chair, that ER would on its own volition drive a particular matter. A matter would have to be initiated from either the manager, instructed by the executive, or the authority, line authority, and ER would then act upon that particular instruction. Thank you, Chair. I hope I've answered your question, Chair.
No, you have. Can you then enlighten us, if you know, and this is talking generally. It appears that cases can take extremely long at the Road Accident Fund to even pursue while somebody is suspended. Do you know how that comes about? It seems bizarre. We've even asked for the list, and there are people who are suspended in 2021, still on suspension.
It centers around a process where we've outsourced the investigations. So what we would normally do is we had a panel of investigators from a internal audit perspective, from a legal and compliance perspective, that would do any investigation of where there's a serious misconduct and it's a major offense, and that in itself takes time. Then the charges would be brought about, Chair, post the investigation, and the CC or the internal disciplinary hearing would then ensue. Now, it's not just that the RAF is litigious outside, but also internally. So there would normally be between the independent. We would appoint an independent chairperson, and the matter would be initiated internally, where that would take some time. But I am aware, Chair, and I can confirm that our cases, or the cases within the Road Accident Fund, took extraordinary time of length to conclude, based on the time it takes for the investigation, based on the time it takes for charges to be put before the employee, and then the actual sitting of the formal disciplinary hearing, which may take time as well, because we, like I said, we do appoint external chairpersons, and it's dependent on their particular calendar to chair a particular matter for us, or in some instances appoint attorneys to initiate on behalf of the RAF. And as soon as that happens, then the employee also have the right of legal representation. So all those factors combined, and considering all that, and that we've outsourced the actual management of the formal disciplinary hearing itself, takes time, Chair. But I do agree with you that the matters did take extraordinary length of time to conclude. Thank you, Chair.
So shouldn't the Road Accident Fund be done with most of the investigation so that it has a basis for taking disciplinary action? It seems strange to me to suspend someone in 2021. And these are not cases at the CCMA. So we've taken the care, we know how many cases are at the CCMA, etc., etc. So these are not concluded within the Road Accident Fund. It's now going to be December 2025. Certainly, the procedure would be to a layperson that there is an investigation that takes place, and either at the end of that investigation or towards the end of that investigation, because it's apparent that the employee is implicated, they are then placed on suspension or given a chance to explain why they shouldn't be placed on suspension. And if their representations aren't good enough, then they are then placed on suspension and a disciplinary process ensues. Now, if it takes months to do that, we're not going to hang you. But years is pushing the limit. It has the appearance of an arbitrary decision, an instruction being given by an irritated manager or executive, irritated with an employee, to demand that they be suspended. And then there is a long investigation to find something. And the fund struggles to find anything against that employee. But that employee remains suspended on full pay, which is our concern here as the committee, because people are getting paid to sit at home, and then others are getting paid possibly an acting allowance and that kind of thing, unnecessarily so. Am I wrong in this expectation that the process ordinarily should work in this way?
Yeah, you are correct that the process should work in ideal word in that particular way. As I've said, Chair, I confirm and do agree that the process within the context of the Road Accident Fund took extremely long. There were instances, Chair, where we would make recommendations for the employee to return to work, and those will not be executed by the line managers. So, from a human capital ER perspective, a recommendation would be made to say there's the investigation. The outcome of the investigation is this: there was no material findings against the employee, or following a CCMA particular process, the CCMA has found the employee did not transgress. In a lot of those instances, we would take the matter on review. Even after recommendation for the employee to return, that decision will not be executed by line. So what I am saying, Chair, is that
why wouldn't they execute, if I may ask? Sorry to interrupt. Why wouldn't they execute? I mean, we've seen these cases where the employee wins at the CCMA, then the Road Accident Fund appeals to the Labour Court. The employee wins at the Labour Court. The Road Accident Fund appeals to the Labour Appeal Court. The employee wins at the Labour Appeal Court. The Road Accident Fund refuses to reinstate the employee because now the case must go to the SCA, to the extent that the court now must issue an enforcement order. And the court issues an enforcement order, and the Road Accident Fund still doesn't adhere to the enforcement order. Then they must go back to court so that somebody can come and now explain before the court why they're not enforcing the court order. It's happened on several occasions, right? I can give you some cases. We're not here to litigate specific cases. I'm talking about the pattern. You've reminded me by saying you would recommend that this person, there is no case against this person, take them back, and then they wouldn't. Why would that happen? Because it happens to have cost the road accident fund a lot of money to litigate all the way and keep losing.
If I can ask you bluntly, it was because of lack of appetite to bring back the employee, especially if the employee was deemed as anti-transformational. There would not be an appetite to bring the employee back into the organization. Why and what the motives was, Chair, I cannot speculate on that. What I can confirm is, Chair, that instances where we have made recommendation for employees to return to work, that it was not executed by line managers. And that instruction may have come from an executive, or it may have come from the CEO himself in some instances, Chair. Thank you.
All right, thank you. The members can deal with the follow-ups later. My final question has to do with the outsourcing. So we've been told by some witnesses before our process that the Road Accident Fund uses external lawyers even in the internal process. Now, like a lot of the members here, I've been a manager in a unionized environment. I know how to initiate a disciplinary. I know how to chair one. I know how to write a verdict and so on, because I was trained by that organization to do so. Also, when the matter goes to the CCMA, because a lot of the matters are not so complex, the ER team would be the one that argues the matter before the CCMA. And you understand the implication is that you want the process to be as low cost as possible for the employee who does not have the resources to do this themselves. And maybe if it then escalates to court and that kind of thing, of course, you'll have lawyers. What we have been told is that the Road Accident Fund uses lawyers even in the internal process. A, is that true? And secondly, why does that happen?
Yeah, to a large extent, it is true. The rationale at that particular point in time and the instructions is that you cannot adjudicate yourself from a RAF perspective. So we had instituted a panel of labor attorneys through our legal department, governance and legal department, that we would use for such matters. So we had a panel of chairpersons and a panel of initiators that the RAF brought in to assist and to manage the initiation and chairing of disciplinary hearings. Chair, that was the rationale advanced by the CEO at that time, the former CEO, that we cannot prosecute ourselves. We are conflicted, so one would need an external party to adjudicate and manage the particular process.
Okay, so you've been at the Road Accident Fund under different CEOs, so you'll now need to help us. We don't want to assume. Which one it is that said so. Which CEO?
It would be the most recent CEO.
Mr. Letswalo.
That's correct, yes.
Okay. All right. Okay, thank you. I don't want to monopolize the space, but thank you very much for your answers. They've just been helpful in setting out the environment and some of the procedures. I'm sure the members will have further questions in that respect, but I would rather they ask on their own. Honorable members, may I then ask you to put up your hands? So we'll go with you, Honorable Beasley, first for 15 minutes to have an interaction with Mr. Barriel, and then it will be Honorable Neil May. Yeah, and then we'll take more hands thereafter. Mr. Beasley?
Thank you, Chair. Greetings, colleagues. Greeting support staff and Mr. Barriel. I am pronouncing your surname, am I right? Is Mr. Barriel?
That is correct, Mr. Beasley, Honorable Beasley.
No,
yes.
Please, yeah, Mr. Beasley's fine. As long as you don't call me Lord, it's fine. So, does the RAF have a policy how long people should be suspended for?
Yes. there is not more than 6 months. If there are extenuating circumstances, that period may be extended by the senior manager ER, the chief human capital officer, and the responsible executive. So 6 months.
I'll put it to you as a human being. Is it fair for somebody to be suspended for 5 years or 4 years when the policy is 6 months? I mean, I'm putting to you as a human being.
No, it's not fair.
And at any stage, did you ever raise your voice and say, listen, this is not fair? I mean, you headed up that department. Did you ever raise your voice? There's a wonderful saying, evil flourishes when good people do nothing. Did you raise your voice and say, listen, this is just not right?
Well, you would raise your voice by submitting a recommendation to the office of the CEO or the executive, stating the outcome of a particular matter, and the recommendation to reintegrate the employee into the RAF. But there would just be no response to that particular request. One must also understand the context of the environment we operated in that. If there was no response, there was no response. That means that the employee would remain on suspension for that particular period in time. Hence, your concern, Honorable Beasley, around the length of time that employees are on suspension. Thank you.
So, I've been in, I'm getting 50 towards the middle age, end of my working career. I've got less days ahead of me than behind me. And I can honestly say that I've never seen people suspended for so long at such a cost. And the thing that really gets to me is it's the financial side. I've added up that the cost for these people to be suspended is 48 million so far. So it's the cost, but it's also the human toil. And as an HR person, surely you have empathy for these people. Surely we've seen grown men cry in these committee meetings the way that they've been treated. To be suspended for 4 or 5 years when you come home to your family and you say, listen, how'd work go today? No, I'm on suspension. It's a cloud that walks around you. It's not the payment. It's a cloud. It's a reputational damage. And I just want to get your thoughts on that, if you don't mind.
It's you. There's no saying you bend so you don't break. Indeed, it was emotionally painful on the human capital colleagues and the colleagues within the Road Excellence Fund, where you would see an employee being suspended and not returned to work. So we are very mindful of that, and I was certainly mindful of that, and very empathetic towards those employees. So yes, Honorable Beasley, the human factor did come in, and some of us, especially in my position, had to make some certain choices around colleagues that one had to suspend or see suspended during the particular period, and it did take its emotional toll on not just me, but also many employees, other employees within the Road Excellence Fund. So from a humanistic point of view, one would understand that and one would empathize with that. But within the environment, you would also then have to abide by what the organization has decided. Thanks. I'm not sure if I'm still.
No, sorry. No, you found my signal actually went away, so you don't have to repeat the answer. I'll pick it up off the transcript. And then you mentioned that line managers don't accept people back. I mean, to me, that is quite a bizarre statement. How can a line manager not accept somebody back? I mean, if the court has ordered somebody goes back to work, it's a company's decision. How can a line manager say, well, I don't want that person back?
Well, maybe I should restate that, Honorable Beasley. there would normally be, out of the outcome of a CCMA matter, there would be a review of that particular matter, which in itself will take time. And that is the decisions that managers had to make in terms of taking a matter on review, and the employee would then remain on suspension with pay.
So, Mr. Barriel, I put it to you that the RAF used public money, and when I say public money, it's money from the fuel levy. So it's coming from everybody. It's coming from the poorest of the poor to the richest of the rich. That we were using money to fight legal battles that the RAF didn't just want to accept the outcome of it. And what the chair said is so apt. Is, you know, I've been a member of a private company and public companies, and the CCMA hearings, we would do it internally because it's so to go and get external guys and to fight a battle, to bring like armored tanks to fight a person who's a clerk, they don't have a chance, and then just to keep on fighting the matter till the people are drained emotionally, financially, physically, because you guys are using public money to fight private individuals. And I just get a sense that there was just this mass bullying going on using state money to fight private individuals. And that's where I really battle on the personal side. It's just I'm battling to grasp that state money was used to bully people into actually submission to the state, of some of them being close to suicide. So just your thoughts on that, if you don't mind.
Indeed. If you have the financial muscle, Honorable Beasley, especially against an employee who does not have the financial resources, the playing field is in favor of the organization that has the financial capability to see this matter through. So indeed, I will concur with you that the organization may have used or did use public funds to fight some of these particular matters, knowing that the expense and the cost involved in litigation, labor litigation, is a costly matter itself. So yes, I will confirm your assertion. Thank you, Honourable Beasley.
No, thank you, Mr. Barriel. I appreciate your honesty, and I really do. It is refreshing. So thank you. And then you mentioned some people aren't taken back because they are anti-transformational. I mean, transformational can mean quite a different context in our country. And so if you can just explain that reference to anti-transformational, if you don't mind, just that context of that word.
Indeed. Thank you, Honourable Beasley. So the RAF was on a journey of transition and transformation. So it spoke to the internal transformation of the RAF from the old dispensation to the new operating model, the new organizational structure. So as soon as it is deemed that you're not supporting that fully, that is when I would say, or use the term, anti-transformational. So it's got absolutely nothing to do. Yeah, it's totally in terms of the organization and where the organization wants to go to, that you are seen or deemed not to support the transition from the old to the new.
Now, I appreciate that. So just the sense that I'm getting, if somebody raised concerns and to say, listen, I don't think that what we're doing is right. It's not in the best interest of the Road Accident Fund. It's not in the best interest of the mandate, that they essentially would be deemed to be anti-transformative and have the book thrown at them. And literally.
I can confirm that, Honourable Beasley. A dumb view would be taken of that particular employee.
Yeah. Thank you, Mr. Barriel. I appreciate the engagement, and once again, I appreciate your honesty. It is refreshing and within this context. So thank you so much. That's me. Thank you, Chair.
Thank you, Honourable Beasley.
Thank you very much, Honourable Beasley, and thanks, Mr. Barriel. Honorable Nilmay, your turn.
Good morning, Chairperson. Good morning, my colleagues here. Good morning, Mr. Barriel. Would you mind if I put my camera off for a better...
No, you can switch it off there.
Okay. No, thank you very much. Mr. Barriel, and I ask all the people that have come before us here, what are your academic qualifications and professional certifications? Are you a member of any professional boards or HR associations? And if so, which ones?
Thank you for that question, Chair. And yes, Honourable Neil May, I am registered with the South African Board of People Practices. My academic qualification is I hold a BCom. I hold a BCom Honours. I hold a postgraduate diploma in management, business management. So that is in a nutshell my academic qualification and professional registration. Thank you, Honourable May.
No, thank you very much. The reason I'm asking that is when you observed all the disciplinary hearings and the use of lawyers that were brought in for this particular disciplinary hearing, did you not think, was that not a form of intimidation in your opinion, considering that you are responsible for the well-being of employees in your organization? And did your wellness, did you have a wellness program in the RAF?
Thank you, Honourable May. Yes, indeed, we did have a wellness program. We have the RAF had what we call iCares, which was a 24/7 assistance to employees, social psycho support to employees. And indeed, I've mentioned previously, Honourable May, that you bend so you don't break. You needed to manage this to the best of your ability to make sure that your internal employees are still functioning optimally and are motivated. And yeah, the toll it takes on employees internally was also great. And hence there were programs devised and developed and interventions developed to ensure that at least employees have the avenue of support during the transition period. Thank you.
Thank you. Now, during this transition period, was it very traumatic for your employees going through this process, in your opinion?
Honourable May, any transformation process, especially when a Section 189 is announced, is traumatic for employees. I must state, however, that the Section 189 was in its infant stages when it was announced, but that in itself, when you go through a organizational structure review impacting employees, it does become extremely stressful on employees. And looking back at reflecting on your earlier question, it then becomes important to have a strong change capability, but moreover, to have a employee assistance program that supports employees through this particular period. Thanks, Honourable May.
No, thank you. Now, coming back to whose idea was it to establish the positions of specialist advisors to the CEO? And what criteria or process was used in appointing individuals to these positions?
If I just connect, I just want to go to my notes quickly. The Human Capital Division received an instruction from the Office of the CEO to establish, I think it was 7 positions around specialists, introducing specialists into the organization. to support the office of the CEO during the transition period in assessing the capability of the RAF currently, but also then to assess the readiness of the organization as well as supporting the transformation journey going forward. So those positions were created to report directly to the office of the CEO. To support the transition, as I've alluded to at the time, and that was my understanding of the particular motivation of the positions itself. Thank you,
Mr. Barriel. Thank you. So how did that? What steps did you take to implement that? Were they advertised? How did that transition take place? Where did these specialist appointments come from, and what was the process?
So the process followed in terms of that, Honourable May, is that, like I said, in March 2020, we received the instruction. We then, for the specialist 7 positions to be created, we developed the job profiles for these particular positions. The profiles were signed off and approved by the office of the CEO. The profiles were graded by an external organization, and from there the recruitment process started. Now, bearing in mind that it was during COVID, the recruitment policy does allow at the time to advertise in respect of scarce and specialist skills, because these were specialist positions. And hence we then transferred these positions to outsource these positions to the agency, a recruitment agency, to conduct the recruitment process on our behalf. So that was the process followed in terms of the recruitment of the specialist position. It was done through one of our recruitment agencies. The recruitment agencies will then follow the procedure in terms of the background checks, the MIE, and following that, an interview panel will then be constituted that did the interviews for these particular positions. So that is in conclusion the process that we followed by creating these seven positions in the office of the CEO. Thank you, Honourable May.
No, thank you. There will be some follow-up questions to that. But how did the secondment of Mr. Mzida from PRASA to the RAF come about? Under what conditions or agreements was the secondment made? You mentioned that you had an outside agency grade these positions. So were they graded on the existing organogram, or were they graded on the so-called new restructuring? And who was the outside agency that came in to grade these positions during that time? So there's 2 questions here. The process, the grading, the company that did that, and which grading structure did you use? The second question is the secondment. How did that secondment come about?
Okay.
Sorry, Honourable Neil, may I ask, I didn't catch the name of the employee that you are referring to. A seconded from PRASA.
The security specialist.
Okay, Mr. Msiza. You said Mr. Modiba. Mr. Modiba did not come from PRASA. Yeah, Mr. Msiza. Okay.
If I may continue, Honourable May, through you, Chair. So we use the grading process for both old positions and new positions. We use the task grading system to grade our positions. So I hope that deals with your first question. The second question, in terms of Mr. Masisa's secondment, was initiated through the office of the CEO. CEO then writes a letter to the, I think it was also the acting CEO of PRASA, at that stage, saying that he has identified gaps within the security or the security function within the RAF. And he would like the assistance from PRASA to second a capable specialist to assist with the security within the Road Accident Fund. The security function reported directly to the CEO or to the office of the CEO in terms of the approved structure. I hope I've answered your questions, Honourable May. Through you, Chair.
Thank you. I'd like to go back to the grading. You didn't quite exactly explain on the grading system, because these positions were not on the original organogram. So that was the one thing. The second thing, was it approved by the board at that stage? Thirdly, you didn't answer who the company was that actually did the grading that came in. You said a service provider came in and did the grading with regards to that. Did you not think that was a bit strange, considering that you had managers in all these specific positions that seemed to be capable with regards to the advice that a CEO would have, and had been there for quite some time? So I want to go a little bit more into that, because if you were intending to restructure the organogram, the grading, I'm still not comfortable with your answer with regards to the grading with regards to that.
So, if I may proceed to you, Chair, the grading would be based. Yes, Chair.
So, Honourable Nel, may I correct me if I've missed you? I've stopped the clock. Did you say what your discomfort is, or what's missing with what your dissatisfaction is with the question on grading?
Yes, Chair. Basically, yes, it was the answer was very, very clinical, in the sense that yes, there was a grading. A company came in and it did the grading. I wanted to know the thinking behind the specialist appointment, in the sense of what grading did they look at? Was it executive grading? What was it? In that line.
Okay, all right. No, I understand you better. I understand you better. Thank you.
Okay.
Please go ahead.
Thank you, Chair. If I may proceed. So the organization that did our grading for us was Deloitte. And they are the proprietors of the task grading system. And I think there's 4 elements to the knowledge, skills, influence. 3 of the roles out of the 4 is that what you would use as a basis for grade a particular job. Looking at the KPAs and KPIs of the particular job. So Deloitte would come in and look at a particular job, say what is based on the knowledge, the complexity, the skills, and the influence required. Where does this job lies within our structure in the organization? We never had a senior manager security within the organization. And with the function moving to the office of the CEO, in terms of the new organizational structure, the CEO then deemed it fit, because in terms of the delegation of powers and functions, the CEO has the power to approve new positions in the RAF structure below executive. So the delegations of authority and power and functions allow the CEO and empower the CEO to make that particular decision. What the CEO most probably wanted is to have a senior manager looking after security within the RAF, and that was his motivation for bringing in. And this position came in at a task level 18, which is a senior manager position in terms of the grading itself. I hope I've covered your questions, Honourable May.
Okay, the last question is, I want to come back to the the secondment from PRASA. What relationship did the RAF have with PRASA that one would actually write to PRASA and ask for assistance when you are actually recruiting through an agency? Were your security managers not competent enough? And why would one second? Are you allowed to second from one state SOE to another in that line? In your opinion, and in HR practices? And was there an agreement between PRASA and RAF?
Through you, Chair. The DPSA framework does allow for secondments between entities, bearing in mind that PRASA and the Road Excellence Fund falls under the same entity. So nothing precluded the CEO from writing to the CEO of PRASA to request a secondment of a security specialist. That was in the CEO's purview to do that, and based on his motivation, which I can't attest to. But clearly, the post of senior manager was created in terms of the structure, reporting to the office of the CEO. And in a nutshell, the CEO then wrote to the CEO of PRASA through the DPSA arrangement and through it being a sister companies to ask and request a secondment of a specialist to come and assist the RAF in terms of its security function. That is to the best of my ability that I can answer that, Honourable May.
Thank you, Chair.
Thank you very much, Honourable Neil May. I've got some follow-ups on this secondment issue. Who called you from the CEO's office about these specialist roles, specifically?
If I recall correctly, Chair, in 2020, it would have been the former Chief Human Capital Officer that would have, together with the CEO, request the creation of the specialists within the office of the CEO.
No, sure, but who spoke to you? Who spoke to you?
It would have been the Chief Human Capital Officer at that stage.
Okay, who was that?
Ms. Lerato Gumbi.
Ms. Lerato Gumbi.
Okay. Currently, yeah.
All right, we'll take note of that. You said that the recruiting agencies did background checks.
Correct.
Did they do conflict of interest? Was conflict of interest part of that?
It would have formed part of it, yes, Chair.
Are you aware that Mr. Msiza and Mr. Letswalo were business partners at the time he was recruited into the Road Accident Fund?
Not aware, Chair. I can confidently and confirm that we were not aware of any relationship between Mr. Letswalo and Mr. Msiza. Okay,
so they were co-directors in a poultry business.
We weren't aware of that at all, Chair. It was not declared at all.
Okay, so then the recruitment company wouldn't have done a good job then of background checking.
Well, that was a secondment, Chair. There would have been no background checks for the security official being seconded from PRASA. One would assume that PRASA did the particular checks, and the secondment arrangement would not involve any background checks. Because it was just a secondment for a certain period from PRASA to the Road Accident Fund. Would
it matter at the time the person moved from secondment to working for the Road Accident Fund?
Chair, can I just ask you to repeat that question, please, Chair?
No, I'm saying so the conflict persists anyway. So sure, you can make that claim with a secondment. But I would expect an ethical chief executive to say, this person that you've brought here is my business partner.
Chair, we were not.
Is that an unfair expectation?
No, it's not an unfair expectation, and one would expect that the conflict of interest would be declared upfront. If it was not, Chair, then yes, you are correct in saying that there would be a serious conflict of interest and unethical.
All right. Ms. Mpomanyasha was also seconded. Would that be correct?
Yes, Chair. She was initially seconded from the department by the former CEO to the RAF.
Okay. So here's what we've been told. Here's the history. So Mr. Msiza used to be at the Road Traffic Management Corporation. Ms. Manyasha was at PRASA. When Mr. Letsoalo joined PRASA, she went to fetch Mr. Msiza from the Road Traffic Management Corporation, and then on and on. So he ends up as a specialist in his office, Mr. Msiza, that is, and Ms. Manyasha ends up as a specialist in Mr. Letsoalo's office, and Mr. Msiza is Mr. Letsoalo's business partner. And I would have expected that the system would pick that up. Was there a secondment agreement between PRASA and the Road Accident Fund?
As I've confirmed, Chair, that to the best of my knowledge, and what I did see was a letter that the CEO wrote to PRASA, and there was a return correspondence from PRASA saying that they would second the security specialists to the Road Accident Fund. That is as far as my knowledge goes until Mr. Msiza was started with the Road Accident Fund, Chair.
Okay.
So I was not aware of any conflict of interest, nor did I think that the recruitment or the human capital department knew of any potential relationship at that particular stage. And I can confirm that. Thank you, Chair.
All right. Okay, thank you. Let me give Honorable Isaac an opportunity to ask some questions. Over to you, sir.
Thank you. Good morning, Chair. Good morning, colleagues. Mr. Barriel, Chairperson, am I audible?
Yes, very clearly so.
Awesome. Okay. Is it okay for me then to just turn off the camera?
No, it's not okay. Yeah, you can turn it off.
Okay. Thank you, Chair. There we go. Okay, Chairperson. This matter has been the issue regarding the discussion on Mr. Modiba and Mr. Msiza has now been explored in great detail, where I wanted to raise a few issues, but I'll try not to be repetitive. Mr. Barriel, if I might just check in with you, are there perhaps any minutes of any meetings or interviews with these two particular individuals that you might be aware of, based on what you have explained?
Through you, Chair, Honorable Isaac, no, I'm not aware of any minutes or discussions that may have taken place. What we did from a human capital perspective, HR perspective, was to deal with the administrative part of onboarding the employees within the organization. For Mr. Modiba through the recruitment agency, following the interview process to onboard them into the organization, as well as to onboard Mr. Sizwa from PRASA being a seconded employee. So I'm not aware of any meetings or minutes prior to that. Thank you.
Okay, thank you for that. If I might ask you this, and with due respect, Mr. Barriel, it's a straightforward question. Were you scared of Mr. Letsoalo, driven by the fact that you might have deemed him to be highly politically connected, that you sometimes made decisions that were perhaps against your professional judgment?
Honorable Isaac, no, I wasn't scared of the CEO. However, within the context of organizations and how you navigate through the organization, you do adapt and you do, for the lack of a better word, maneuver through the system to ensure that you are psychologically safe and that you can still operate and function within the organization, bearing in mind that if you are the acting head of human capital, you need to ensure that you do protect the employees and you do absorb much of the pressure that may come from that particular level. So there were a culture of fear within the road exit fund, especially at a senior management level for the CEO. And I'm being very honest if I say that you do not get on his wrong side. Or yeah. So, but from scared, no. Adaptable and being able to navigate through the maze is what the survival tactic was at that particular stage. Thank you.
Thank you for that, Mr. Barriel. Just I'm trying to also educate myself and understand the dynamics somewhat better. Through you, Chairperson. Mr. Barriel, do you perhaps feel like the road accident fund policy was changed to have the CEO make decisions to perhaps suspend people, maybe to serve his personal agendas? Or is there a professional basis for that change? What are your comments on that, sir?
Certainly, in hindsight, Honorable Isaac, some of those processes, policies may have been manipulated to serve a particular purpose, and that I can attest to. Yeah, so that particular motivation or modus operandi did exist in terms of using the current policies to the best and stress test those policies, provisions of those policies to make sure that one operates within the confines of the policy and practices, but certainly to the benefit of the in terms of your questions to the CEO. Thank you.
Sorry, may I interrupt, Honorable Isaac? I'll stop the clock. Can you be more specific, Mr. Barriel? Because I also don't want us to engage in broad statements and then we speculate, because the committee has to make specific findings. Can you give an example of something like what you are describing? Otherwise, we still can't work out what you are saying.
Well, let me use the example of Mr. Modiba, then Chairperson. We follow the recruitment process in line with the prescripts of the policy. And similarly, one now realizes after the fact that there may be a relationship between the CEO and Mr. Modiba. And that's an example I would use.
Okay, but I mean, to the best of your knowledge, was the recruitment process for Mr. Modiba proper? I'm trying to understand your hindsight, and when you say there may have been a relationship, because you then also don't describe the relationship. I want us to. So when I was asking about Mr. Caesar and said they're business partners, I know the name of the company. We've got the company registration number. The two of them are directors of that company. And I named it in the committee. So I did not speculate. So I just want to say that when we make assertions like this, we need to be specific. So you say you followed proper process. So I'm going to ask you, and my apologies, Honorable Isaac. I just want us to kind of set a way in which we provide information to the committee. So, one, you say the process was conducted properly, and then later on you realize there may have been a relationship. Now, I need you to help us on both. If the process was run accordingly, then as long as if there's a relationship, the conflict is declared, maybe it's not an issue. You need to assist us with specifics so that we understand the basis of your statement.
Okay. Thank you, Chair. Chair, like I said, I did confirm that the process followed, recruitment process, was a fair and transparent process through the agency. So Mr. Modiba was the preferred candidate, and on the upon recommendation from the particular panel that did the interview. But it became apparent after that the CEO and Mr. Modiba may have worked together previously in a previous organization. So perhaps my comment was premature in terms of saying there was a relationship, but clearly it became apparent afterwards that they did work together at some point.
Where did they work together, if I may? Where did they work together?
I cannot confirm that. So as I'm saying, it is. I lack the specifics around that.
Okay, so in my introduction, I apologize again, Honorable Isaac. In my introduction, if you recall, I said that let's stick to things that are within our knowledge, right? So you can attest to the process followed, and I'd like to ask you some questions later about that process. That's fine. But if you heard from someone that they may have worked together, it's of no value to us, because now we're asking you these questions and you're not able to provide answers. You see, and now we're not able to. So try and stick to what you know, at least where you can point us in a direction where we can get the information. If there's something that is speculative or you heard, it's best to stay away from it, because then we still can't make conclusions on it as a committee. I hope that explains. So that is why I intervened in this case. Otherwise, I hope you understand me. All right. Okay, Thank you very much. I'll resume the clock. Thanks for your indulgence.
No problem, Chair. I appreciate your expertise. So thank you for some guidance there. Again, we were on this topic. Maybe I should just ask Mr. Barriel then, do you honestly speaking now, do you feel that the ER department was truly independent, or was it to a certain extent being run by the CEO's office?
Honorable Isaac, again, not to speculate, but my observation was that there was to a large extent influence exerted by the office of the CEO on the ER department in matters. Yes, I can confirm that there was great influence in terms of the office of the CEO on the employee relations department.
Okay, great. You see, that's what I needed to understand, whether there was pressure from, powers above you, and obviously I can gauge that you were probably feeling a great extent of discomfort, where sometimes you were being dictated to, if I am correct. Did you then perhaps ever question yourself, why are these specialists that the CEO was bringing into the organization, and that the fact that their roles were not in the new structure? Did you question that?
Honorable Isaac, based on the guidance from the chair, I would speculate what the motivation might have been. From an organization perspective, and what I understand was to assist the office of the CEO with the transition and transformation of the Road Excellence Fund. So that is as far as my knowledge goes, and what I have seen in terms of the motivation to bring the 7 specialists in. Thank you, Honorable Isaac, and to you, Chair.
Okay. If I may go ahead, still, Chair, I'm not sure of my timeline.
No, I had stopped the clock when I intervened so that I don't eat into your time. So you can still proceed. You've got another 7-8 minutes left.
Awesome. Okay, good. Mr. Barriel, how did you then deal with matters where managers were threatened by the RAF lawyers and ER specialists to sometimes go and actually lie in a hearing for employees?
Through you, Chair. Honorable Isaac, I'm unaware of an instruction from ER or an instruction given to ER to lie within hearings. So I cannot comment on that particular issue that you just raised.
Okay, I understand where you're coming from. All right, let's allow that one to slide for now. Then I must ask again, with due respect, Mr. Barriel, how do you then justify the bill increase when you now had these law firms that were used as investigators, that is RAF lawyers and initiators?
As I've alluded to, Honorable Isaac, that was an instruction and a new practice that we've instituted to use attorney firms to assist the ER department in terms of managing these matters from a formal disciplinary hearing internally and at the CCMA level. So, of course, that would have resulted in an increase in the cost. Bearing in mind, as I've said earlier on, this was done through a panel of attorneys through your legal governance and legal department to assist the ER department in managing some of these matters. So there would have been an increase in the cost. Yes, I do agree with that.
Okay. So you accept there was a huge increase in the costs and that you were fully aware of that, right?
Correct. Yes.
Okay, I just need to get some solid understanding behind that. Is there any thought, perhaps, that you might have been giving managers an ultimatum to sign suspension letters, or alternatively might have promised to suspend them in turn if they did not suspend their team members? Were you under pressure at any point in time?
Honorable Isaac, through you, Chair, I'm not aware of there being threats against managers to sign suspension letters. In terms of the disciplinary policy, it would have been the senior manager, ER, and the executive that would have signed, the responsible executive that would have signed and approved the suspension of a particular employee if there was a transgression. But I can confirm that I'm unaware of there being threats against a particular manager that if he or she does not sign a suspension letter, that he or she would be suspended. I'm not aware of such instances. Thank you.
Okay, then in conclusion, if you'd allow me, Chairperson, I just want to finally ask this one. In the initial opening remarks of the Chairperson when we commenced with the meeting, Chairperson spoke to the PwC matter. Just for clarity, can you perhaps just take the committee through the process of how the structure was developed with PwC? What I'm actually wanting to get at is, at what point did Mr. Letswalo say to you, he does not like what PwC presented initially as a new structure, and he suggested that it should be reworked. I mean, did you then question why the specialists and the reworking of this whole thing was suggested?
Through you, Chair, Honorable Isaac, I'm not aware that there was any dissatisfaction with the structure. As I've said and alluded to in my opening remarks around the organizational structure review, that the work done by PwC was a much collaborative effort between the CEO, the execs, and key staff members within the organization. The structure was co-designed, and I think the CEO and the executive, especially the CEO, made input into what they term the quantum leap structure, in terms of the strategy, as well as the opportunities that may arise from the new structure going forward. So I am unaware of any dissatisfaction. I am aware that there was co-creation and that the PwC did meet with the CEO to take input in terms of the strategic direction, as well as with the executives in terms of designing the operating, or not the operating, the organizational structure fit for purpose. Thank you.
Okay, and then thank you for that, Mr. Barriel. And then finally, just in a nutshell, I want to find out from you. Do you feel like you have been used? What would you like to say to your colleagues at RAF from a hindsight point of view? I've just combined these two questions. Do you honestly feel like you've been used at a certain point in time? What would you say to your colleagues? Thank you.
Thank you, Honorable Issa, through you, Chair. Well, I think use is a strong word, Honorable Isaac. I think starting with the Road Excellence Fund in 2010, there was a relationship between myself and the organization. The organization I deeply cared for in terms of its people, and the trajectory of the organization going forward. Certainly from a contract perspective and opportunity perspective, one might feel that the organization in the later years were not fair in terms of how they treated or the opportunities they provided for us to competitively compete for positions. But as I've said, there was no guarantee, and it is a competitive process that one would follow for a particular position within the Road Excellence Fund. So I wouldn't say I was used. There was a reciprocal relationship. I did what I love in terms of people management, and that was my passion. It is a balance that one must strike in terms of the work we do, especially within state-owned entities. Thank you, Honorable Isaac. Through you, Chair.
Thank you, Chair. I'm done. Thank you. Thank you, Mr. Bannister.
Thank you very much, Honorable Isaac. So I think we're going to take one more member and then allow you time for a body break, and to also recover Mr. Barriel, if that's okay. You feel you can take one more round?
Yes, please, Chair.
Okay, all right. No, that's fine. Honorable Mente, your time starts now. It's 15 minutes.
Thank you very much, Chair. Good morning to the colleagues and good morning to Mr. Barriel.
Good morning, Honorable Mente.
Yeah, thank you very much. I just want to get a few clarities from you. And you may answer them as precise as possible. And if where you do not know, feel free to say, no, this one is unknown to me. First thing I want to establish is, what is your understanding of the mandate of RAF when you arrived? And you just beautifully said, gave us your relationship with RAF ever since you started until you left. What's your understanding of the mandate of RAF?
The mandate of the Road Accident Fund, as I understand it, Honorable Mente, was to indemnify wrongdoer, one. Two, to put a person that was involved, injured or death, to compensate that particular person, either injured or the family members of the particular person that have passed away as a result of an accident, to compensate them and to put them in a position, again, where they can, as a family, function going forward. So that was the purpose and mandate, in my view, of the Road Accident Fund, in layman's terms.
No,
Thank you.
Beautiful. Thank you very much. That is beautiful. Now, leading to my next question is that in your position where you were involved in human resource and wellness, or rather the overall resourcing of the organization, what was your contribution in order for the fulfillment of the mandate of RAF?
Honorable Menti, you were not very audible. Do you mind just repeating the question again? I'm just going to try and put my speaker louder so that I can clearly hear you.
Oh, okay. No, thank you. What I want to understand is, in your position when you were serving at RAF, what was your role in realizing the mandate of RAF, in particular, in serving those that are affected by the road accidents, those that lose their families, and those that must be compensated for being injured in our road? So what was your contribution and your role in the space of RAF?
My role in the end result, or realizing the mandate of the Road Accident Fund, clearly lies in a couple of elements from a human resources perspective. One is to ensure a capacitated road accident fund. Two is to ensure a capable road accident fund in terms of its human resources to be able to fulfill and facilitate the mandate of the Road Accident Fund. Three was to create a conducive working environment for employees within the Road Accident Fund in fulfilling that particular mandate. So those are the three key elements, I would say, Honorable Mente, in terms of my role from a human resources perspective in enabling the RAF to fulfill its particular mandate. Thank you.
No, thank you very much. So in your role as well, ensuring that there is sufficient human resource and there is wellness for the personnel, did you in your tenure have any personnel that gets fired at RAF or dismissed for any wrongdoing? And if you had, did they go to CCMA? And how were you representing RAF at CCMA when they take CCMA to, when they take RAF to CCMA?
My apologies, Honorable Mente. Like I said, you're very faint in terms of the audio that comes through to my side. So if I can just ask you to repeat the question for me, to enable me to fully respond to the question, Honorable Mente.
Okay. In your role as a human resource leadership, as well as ensuring that there's wellness for personnel, were there any of your staff across RAF, or rather in your office, that were ever dismissed? And why were they dismissed? Did they go to CCMA? And who was representing RAF at CCMA when those staff members take RAF to CCMA?
Honourable Mente, it would be difficult to point to a particular employee. I'm not aware of a particular employee. So I do not have specifics around a particular employee that was dismissed and went to the CCMA. Certainly from a human capital perspective, there are employees where there are misconduct, and those employees would be taken through a disciplinary process. And if they are not satisfied with the outcome of the disciplinary process, they have the right to take the matter to external bodies like the CCMA. I'm unaware of any specific matter. And my response would then be applicable to the broader RAF employees as well, Honourable Mente. Thank you.
When they get to CCMA, who was representing RAF?
Normally at the CCMA, you would have during conciliation, you would have the senior manager ER or a manager ER representing the RAF. And an employee may have a representative that is not a legal representative during conciliation. During arbitration, you would have the senior manager or a manager ER representing the Road Accident Fund. In the new dispensation, that would be if legal representation is allowed by the commissioner, we would then in-source an attorney as the representative for and on behalf of the Road Accident Fund, and the same would then be offered to the defendant or if he or she needs legal representation. But that is a determination by the commissioner, him or herself, during the particular process. Thank you.
Okay, thank you. No, that helps us, because I want to understand the situation where lawyers are representing personnel of RAF and what is the requirement. So it helps us to understand that it is not new that RAF has submitted, or rather sent, legal representation, not just submitted it on paper, but sent legal representatives in some cases. And you were outsourcing before in your tenure. You do have knowledge of insourcing some of the legal expertise. Is that what you're saying?
Yes, it's not uncommon for the RAF, like I said, upon application to the particular commissioner, especially during arbitration, for us to appoint legal representation. As I've alluded to earlier on, Honourable Mente, that is a model that we've instituted to use legal representatives to assist, especially in complex ER matters at the CCMA. Thank you.
Okay, thank you. As much as you may not pinpoint to a particular case, in your tenure maybe, do you have any personnel of RAF that has ever won an award from CCMA that they must be reinstated and you adhered to an award?
Yes, where there's a CCMA outcome in terms of the process and there's an award, one would honor that particular award as an outcome by the CCMA. So yes, I am aware of matters where that award would have been settled, either based on the merits of the particular matter, and based on the feedback from the ER person or the ER manager, that award would then be honored in terms of the CCMA outcome, and that is normal process.
Well, thank you. So did you agree to all awards, or you have taken some of the awards to the higher platforms to argue the awards? Did you agree to all of them, or did you review them?
And to a large extent, the matters, if there is grounds for review, one would take the matter on review. The process normally followed was that one would ask for an opinion, legal opinion, in terms of the prospects of the, and if there were any defaults found in terms of the process or the outcome of a particular matter, one would ask for an opinion, legal opinion, and based on that legal opinion, one would then take the matter on review.
Thank you for that. So in the current operations around HR in particular, and what you know at RAF, is there something different?
It's not something different or out of the ordinary to take a matter on review if the organization feels it has a strong case going forward. It's not out of the ordinary to take a matter on review. But normally organizations do adhere to the CCMA in terms of if there's an outcome to implement that particular outcome. But it's not uncommon to take a matter on review to the labor court, for instance.
And who goes to represent the RAF when you take the matters on review?
It would normally be an attorney, a legal representative.
And no one else can do the job except for an attorney.
That is correct, especially at the labor court.
And where will you source these attorneys? Are they you do have internal attorneys that do this, or do they get outsourced as well?
It was outsourced, and we used the panel that has been appointed by our legal department. So we would then request a legal firm to be appointed to deal with a particular matter from the legal department internally, as part of the panel that they have, attorney panel that they have that services the RAF. Thank you.
Okay, no, thank you very much. Now, let's go back to the mandate and the resourcing of the mandate thereof. People that get injured are people who are in the main not privileged to information. Therefore, RAF has to, one, put itself out there so that people do know what the process is. If you happen, God forbid, to be injured and get into an accident, and how the process should unfold. Secondly, there should be people to welcome you at the RAF office should you choose to come there and compile whatever necessary information in order for your claim to be processed. Then number three are the people that are, besides this promotion of RAF and the process and how it unfolds, two is the actual process of a person that claims, which must be resourced. And three is what happens after the person. So every personnel or rather department that has to be put in place to realize or rather to finalize the claim. Do you know if that process was in place? Were you satisfied with how the process was, and was it properly resourced?
Honorable Mente, there was always a shortage of staff within the road accident fund in terms of your claims management, and I think previous witnesses have attested to that. There was a process, the recent process or the recent model focused on lodgement and to make lodgement easier for the claimant coming into the office of the RAF. So, and I know that the committee has previously examined what they term the registration of claims and personal claims versus representative claims. But people coming into the RAF, one needed to make sure that people know what to do and assist the claimant in registering or lodging their particular claims within the road accident fund. Of lately, the promotion of the claims process. I'm not aware after 2024 of the additional campaigns, but previously there was a lot of campaigns running around road shows to educate South African citizens around the claims process, what they can claim for, and where to go in terms of registering or lodging a particular claim. So it is always an important factor to make sure that South Africans know and is aware and educated on the process of lodgement, the process of the claims administration, and that is a duty that the RAF have to make sure that potential claimants know what the process is in terms of the claims administration. Thank you.
Thank you. Now, you are saying you are not sure of what is happening now in terms of the promotion of how people claim. And there is a claim that was made, rather not a claim, an indication that was made by many people who came before us, and that seeks to paint a picture that direct claims were stopped. Do you perhaps know what happens with direct claims and now a promotion of using lawyers than people coming direct and get help from RAF officers?
There was not an active, through the Honourable Mente, in terms of the post with the new strategy of the Road Accident Fund to promote direct claims. So there was no active marketing or appetite for direct claims. What happened to the current direct claims that we had on our books was to administer them to the best of the ability and to establish ring-fence staff members that would focus on managing the direct claims that came into the Road Accident Fund. The emphasis of late was the lodgement and to make the lodgement of the claim much easier and accessible. That was the intention in terms of creating that environment where people are able to lodge a particular claim. Similar to have offices in across South Africa to make it accessible for claimants to come and lodge a claim with the Road Accident Fund.
Honorable Member, so I've indulged you for 20 minutes, so ask one more question and then I recognize that you were not with us for much of the week, so I let it go on. But please ask one or two more questions and then we'll go on break. Honorable Member?
Thank you, Chair. Sorry, I muted my mic. Yeah.
Okay, that's fine. No, you get extra privileges because you are not around.
All right, thank you, Chair. Mr. Barriel, so you're saying there was no direct instruction to anyone that direct claims must stop?
I'm not aware of a pertinent instruction. That instruction may have gone somewhere else, but I'm not aware of a direct instruction. All I know is that direct claims, there was no appetite for direct claims, and that didn't form part of the strategy going forward for us to go out and source claims within the community. What I do say, Honorable Mente, is that much was focused on the administration of that particular claim. Direct claims, it really didn't form part of the new strategy. There was a view that direct claims, as with in my understanding of the RAF Form 1, that most claims were registered and did not have the documentation it was supposed to have for a successful lodgement of the particular claim. So there was really no appetite for direct claims in the new dispensation. I can confirm that. Thank you.
No, thank you very much. Earlier on, you explained a role of DPSA in a situation where there's secondment and the regulation thereof. I want to understand from you just one thing. In fact, I think it will be two things. One, do you understand or know why was the CEO seconded there in 2019? Secondly, after being a CEO, was he prohibited from seconding any type of skill that he required at RAF? Or is there any law that prohibits him from seconding any skill at RAF that he may identify in particular under the sister companies in the same company, in the same department? Thank you.
Thank you, Honorable Mente. Through you, Chair. It may have been in the purview of the former minister seconding the former CEO in 2019 to the RAF, and that lies within the ambit of the minister and the Department of Transport. And that's my comment on the first question, Honorable Member. The second one is that within the framework, nothing prohibits the CEO of writing to sister entities to second capabilities from another entity. Thank you.
Thank you. I'm fine, Chair.
Thank you very much, Honorable Mende. Before we go on break, Mr. Barriel, I just want you to explain something to me. What do you mean there was no appetite for direct claims? What does that mean in practice?
In practice, it means that we didn't. So in the previous dispensation, Chair, There was
Just give time period. So that's more helpful when you say
before the current new strategy and CEO, there was a direct effort to go out to communities to register claims or to make known that the RAF exists, and that the communities out there have the ability to register claims with the RAF should there have been an accident.
Right.
So post with the advent of the new CEO, that particular initiative was stopped in terms of what we used to call RAF on the road, to actively go and market the RAF for direct claims in communities. So that is in a nutshell what I am saying, Chair.
Were you made aware of the reasons why that was so?
Chair, the best of my knowledge and my own assessment was because there was the backlog, one. Two, that claims were registered without any proper documentation. Three, some of those claims were not valid. And it increased the volume of claims that came into the organization that may not have been valid claims. So that is my assessment of why it was stopped, or the appetite was not there for direct claims, Chair.
So Makitosh Paulela appeared before the committee, and if I'm mistaken, please, no, yeah, if I'm mistaken, because I may be confusing you with Brian Furness, but please correct me if I'm wrong, that he had a conversation with you about this, and you expressed a similar view to say, we do not go out and actively promote direct claims. Do you recall such a conversation with him?
Yeah, I may not directly recall the conversation, but that was the thinking at the particular time. Not the thinking that was the particular strategy at the time, that we will not promote direct claims. So you may be correct. I can't remember the specific conversation.
Sure. But the general sentiment is correct.
Quite correct, yes, Chair.
It accords with what you're saying. Final question, and then we'll take a 10-minute break. It's got to do with something Ms. Mtetra, one of our witnesses, told us, because she worked in claims origination, that subsequent to that decision, and in terms of the documents we had, there does appear to have been a board decision to do so. So it wasn't an arbitrary decision by the chief executive. So it appears to have been a board decision to do so. She then shared with us that the claims origination team was then withdrawn from the areas, from the hospitals and so on in which they were, and they were taken to, I think, customer service centers, CSCs, and so on, and she ended up in Johannesburg. Would the gist of that testimony be accurate or untrue?
The gist of it would be correct, Chair. I can't attest to the board resolution or the board directive, but certainly from a hospital service consultants were withdrawn and moved to CSCs. That I can confirm, Chair.
Okay. No, thank you so much. It's 11:05, Mr. Barriel. You need to get your voice some rest. So can we take a 10-minute break and come back at 11:15, if that's okay? Then Honorable Madlala will resume with you. But thank you very much for answering all the members' questions so far.
Thank you so much, Chair.
All right, thank you. Mr. Barriel, are you back?
Yes, I am, Chair.
Okay, thank you. I hope that break has been useful.
Indeed,
Honorable
thank
Madal.
you.
Honorable Madal. Yeah, I think, Mr. Barriel, you've answered all the questions, and Mr. Madlala has changed his mind because he's not answering yet. So, Honorable Madlala, are you available?
Thank you, Chair.
Okay, good. Okay, over to you, sir.
Thank you. I want to just make sure that the witness can see, and then I'll close the video. Now, I don't know how to open it. As a Rotarian from Umzombe, I must be workshopped on this thing.
I thought you were in Dubai.
No. Those are Matuna's things. The opulent class. We are the poor working class of the country. Nonetheless, let me proceed, Chair. Maybe I'll get this thing right at some point. Greetings, Sir Mr. Barriel. I'm not sure if I'm correct. I'm pronouncing the surname correct.
Indeed,
how are you?
Honourable. I'm good, thank you, Honourable Member.
I'm good. I've got just a few questions for you. You said you were with the RAF until February 2024. Is that correct?
That is correct, Honourable Member, until March 2024.
Until March, okay.
Yeah.
How did you part ways with RAF?
How did I part ways with Rav? It's a bit of a twisted story, but in the main, Honourable Member, my contract was renewed. There was a request for me to stay on a further 3 months, but that request only came in after the 2nd of April, after the end of March. So I've decided then to in terms of my contract coming to an end, the 31st of March, for that to come into effect. And I did not accept the further contract extension of a further 3 months that I only received 2 days, the weekend after the 31st of March. So that is how I parted ways with the RAF. My contract, in effect, terminated at that particular point in time.
Oh, so you were on contract?
I was on contract, yes.
Well, what nature of the contract?
It was a further extension for 6 months, 6 to 7 months, 6 months. From my initial.
Sorry, my question is: was it a 5-year fixed contract? What kind of a contract was it?
It was a 5-year contract that was extended for a further period of 30 months in total.
Mind telling why you did not accept the further extension?
Well, I felt there was a bit of abuse in terms of mistreatment. That on 2 occasions, the previous 6 months, my contract was renewed a week before. And subsequent to that, the contract was renewed only after the fact, after my contract is actually terminated on the 31st of March. So that was the one issue. The second issue is that at that stage, the continuous extensions of contracts did not provide stability in my personal life, and I needed stability going forward in terms of having a secure and gainful employment.
All right. Currently, are you employed?
Yes, I've able to secure employment from March this year. I have been unemployed for quite some time in terms of since March last year up to March this year. So that's a total about 12 months.
All right, thank you. And the reason why I'm asking these questions at the very beginning of our engagement is because I would have assumed that you would have found employment by now, which you have, even though it may have taken just a bit of time. And the reason for this line of questioning is that at the level of a senior executive, or at the level at which you are operating with your experience and qualifications, whilst there is high levels of unemployment in the country and challenges around that, but an experienced executive of high ethical and moral ground and competence is likely to stand a better probability of securing employment. And that would, in my own thinking, mean it would not be justified for one at that level to then act out of instructions that actually questions their own integrity. And many people who have came before this platform have expressed indications that some of the advices that they've given, they had given to the executive of RAF, the CEO in particular, were not heeded to. And I've asked many of them, or some of them, what they did in terms of strategic interventions to guide or to counter. For example, if the CEO says, I'm not going to reinstate certain employees, despite the advice, what then has been an intervention? Maybe this is a question directly to yourself. What further intervention would you have gone to save the integrity of the company, or to save even the cost of the company? Because in a governance environment, unlike in a private company, the CEO reports to the board reports to the minister reports to parliament, and all of that. There's quite a huge and a long line of reporting. So there's endless avenue for a senior executive to explore if they feel that there is an action that is untoward, which may cause public purse by an entity. So in instances where you have felt that we should be adhering to the CCMA order or to a court case, and this is not warranted, what interventions, you can just give us one example, what interventions have you put in place or have you tried to explore which could have went unheeded, but in terms of your own action and in terms of your own integrity? Thank you.
If I may, Honourable Member, to answer it in that, let me start off by saying advice can be given, recommendations can be made, but the receptor, if somebody is not receptive to taking on recommendations and advice, it becomes very difficult. Certainly, you would have been experiencing through this particular inquiry that there was really no way that you could influence the CEO. If he has made up his mind, he's made up his mind, and his stance was his stance. So, from a person that seeks employment or seeks gainful employment, as you've said, or that needs to secure the contract for the next 6 months, it becomes very difficult then to navigate, and hence my decision to leave the RAF and not renew my contract. It's precisely for that particular conflict that one felt internal, and that's why I didn't go back to the RAF. So if you ask me, and I think it's a pertinent question, what evidence, what avenues could one use to address if there's wrongdoing in the RAF. In some instances, you are right that some people may have written to the board, some people may have written to the Department of Transport, but even that did not yield any results at that particular point in time. So that means you either make two decisions in what we call flight or fight. You then terminate, you remove yourself from the situation in terms of the road accident fund and my relationship with it of late. So that is the one question I want to that is the answer I want to give you from one perspective, and then going back to the first question is, in order to give advice, and there must be a reciprocal a posture from the other party to accept any advice and recommendation, and which there was not during the 10 year I was acting. Thank you.
All right, I do get your response. So in a nutshell, what you're saying is that you felt overpowered in terms of what could have been your possible advice and guidance, and you opted to then stay until your contract ended, and then you decided not to renew your contract.
I think in summary, you have the gist of the understanding correct, Honourable Member.
And during your stay until the contract expired, do you feel that there were certain decisions that you had to implement which were not in line with what you believed was right?
I think that's a very direct question. I can't pinpoint one. There's certainly decisions around suspensions and so forth that I have to implement. And that was a clear directive, and that you had to execute. And based on the outcome, so I can't pinpoint. It will be speculation for me to pinpoint any particular decision that I've implemented. There was a lot of decisions that was implemented, Honourable Member.
So you can't pinpoint anyone which you believe that it was not, which was against your own advice. Let me just put it like that. Where you gave counsel, that counsel was ignored, and then you still had to go ahead and implement the decision, which was against your own initial advice to executive, but then executive would have insisted that you proceed.
If I may give you an example, the organizational structure review, for instance, the advice was to not if when we migrate employees to the new structure, and to new jobs, not to reduce the benefits of that particular class of employees, where they may be placed in a lower job, which they have been doing, but because of the regrading, the job comes out not lower. So my advice was, from a human capital perspective, for the benefits to remain at that particular level. That was not received well. And the instruction was for us to implement the reduction of benefits until such time as the union then lodged an objection. That is when the process was halted. So there is an example of recommendations that were given that was not received well, and an instruction given to implement the particular decision from a CEO exco perspective.
All right. Let me move on to the next question. I will make a comment towards the end. We are limited by time. In terms of there was Ms. Mteto who presented herself before this committee, and not just only her, but many people pointed to ER, which I think was a division under your department, as the hitman, if I may say, for the lack of a better word, but as an instrument of victimization of employees. For example, Ms. Mthetwa spoke about the suspension of over 200, I can't remember the exact number, of people who are dealing with direct claims. And she says in her own investigation, when he was instructed that they should be suspended, when he looked into the matter, he found that it was because the challenge of meeting the 180 days lodging of claims and all of that, which was part of the allegations, was not because of the incompetence of the employees. It was because of the systematic failures. And then she says, nonetheless, ER went on to process those suspensions, and it was clear that there was an unwritten instruction that those employees needed to be gotten rid of. So ultimately, those employees were dismissed, and many others became victims following to that. And this she places on ER as a responsible or as a tool of effecting. What is your comment around that particular situation? In a nutshell, did you do your own investigation, whether directly or through the panel that you said you had? And then did you find differently that employees could have done something better in terms of ensuring that they meet with the 180 lodging of claims, despite the quantitative overload and all of that? And what was your recommendation, which led to ultimately their suspension and ultimately their dismissal?
Thank you, Honourable Member. Honourable Member, I think it would be unfair to squarely put the blame for a particular process on the Employee Relations Department. The Employee Relations Department facilitates discipline within the organization. It is the manager who determines the misconduct, and after consultation with ER, then determine the veracity of that particular misconduct. So it is the manager and the senior manager and the executives that would make a determination in terms of the misconduct, guided by ER through the process. So I just feel I need to put the record straight that you cannot pinpoint the particular scenario squarely on employee relations in terms of discipline within the organizations, or that ER was used as an instrument or as a instrument as a hitman. So I just needed to clarify that, Honourable Member. Second to that, the 180 days, Honourable Member, it is the manager that needed to do an investigation of what led to the employee not meeting or meeting the court order or payment in terms of 180 days, and what led to that particular situation. Based on that, there would have been an investigation, and based on that, there would have been a disciplinary hearing. I am uncertain if there were employees. And I can't say that if the employees dismissed because of that. If there were dismissals, it was as a result of an outcome of a disciplinary hearing where misconduct may have been determined, may it be from a fruitless and wasteful expenditure, may it be from a negligence perspective, but there would have been a process followed and there was an outcome, bearing in mind that the process may have taken some time. So that is my response to you, Honourable Member, in terms of the ER department in the 180 days.
All right. Okay. Thank you. Thank you for that response. Let me just state to you, I think I've noted your response, but that what Ms. Mthetwa said was, I asked her specifically if then the investigation, her own investigation was the basis, because that's how I understand the process as well, as a human capital person myself, that the line manager will conduct an investigation and make recommendations. Obviously, the line manager would then be a witness and not necessarily prosecute in some instances if it was directly linked, or if he was the first person to interact with the situation. But Ms. Mthetwa said her own investigation's findings were that there was no need for suspensions. However, ER proceeded. So I wanted to assume that what that meant is that ER conducted a separate investigation, because if they had attached the same investigation, it would not make sense for the suspensions to proceed. But I note your response. I think what you are saying is that her as a line manager would have been the one who did an investigation, and the hearing would have proceeded on the basis of that investigation. Such contradictory statements from yourself and her, but I think at some point would arrive at what could have been the reality. Let me just move to the next question. I'm sure I've got a few minutes if I've not went over by a few. Let me just move to the next question.
You are in injury time, but I'm in a good mood today, Honorable Matlala. Finish your question.
All right, thank you. Thank you, Chair. I wanted to then go to the secondment of Mr. Msiza. There was an issue canvassed area in relation to the documentation which was provided, or in terms of the checks, or the background checks. And the response was that the assumption was that those background checks would have been done by PRASA. And if my recollection of all of this is correct. I want to first understand, how long was the secondment for? Was it a permanent secondment, or was it supposed to be for a fixed term period?
In my recollection, Honourable Member, the secondment was going to be for a fixed period. And if I recall correctly, it was extended for the seconded party, Mr. Msiza, to come and deal and with the perceived issues as per the CEO in his office, him being the security reporting into his particular office. So the secondment, yeah.
Okay. So did PRASA hand over the employee file to you guys? Because my understanding is that if a person is seconded to a position that exists, they would still have to meet the requirements for that position. I mean, the company, you cannot second, for example, a person with matric or who does not meet the requirements completely into a position that had been created into the structure, unless if there's no position and there's a strategic decision to say borrow us this person and you'll continue paying them, because obviously if there's no structure, that means their salary remains on the other component of the state entity, if that is permissible. But if it's within one organization, then you'd expect that there would be some transfer documents that are filled. I just want to understand, in terms of the situation, whether a file was handed over and whether you guys did due diligence to check if everything was in line or was in order with it.
I wasn't directly involved in the administration of the secondment. That would normally be handled by our administrative or the RAF's administrative department, with the administrator on the other side in terms of PRASA. But in terms of the current position, that position was created in the office of the CEO, the senior manager of the position, at his prerogative and as per the delegation of authority, powers and functions. And that position was graded, and Mr. Msiza applied for that particular position and was a successful candidate. That is the process that was followed in terms of my understanding, Honourable Member.
So when you're saying that you are not involved with the administration, under who does that administration part dealing with secondments fall? Would it not be under, or you are saying you were not there at the time, or would it not be under your department?
No, it would be under human capital. What I am saying is there's a senior manager that deals with it, with the administration. So once the CEOs have agreed that the employee or the incumbent would be transferred, that is where the exchange of letters would take place. There was an arrangement that the RAF would take over the salary of Mr. Msiza in terms of his PRASA salary at the time. But I cannot give you details at this particular moment in terms of the actual content of the letters and the administration papers that was exchanged between the Road Accident Fund and PRASA.
Okay, no, it's fine. I think I also get your answer. I still believe that as a senior person with such an appointment, you would have had a role to play in terms of ensuring that all the checks and balances are done. But you are saying the senior manager. I assume that the senior manager reports to who? To yourself.
Correct.
All right. No, thank you. Let me go. Let me move to the next.
Last one.
Question. Yeah.
Last one.
The last one, Chair. Yes.
Yeah.
So the position of a security specialist that Mr. Msiza currently sits in was advertised twice. It was first advertised with an NQF above level 6. Mr. Msiza is NQF level 6. It was advertised with a higher qualification, and it was declared an appointment. And then it was re-advertised with a lower qualification. Can you explain what was the reason for lowering the qualification requirement of that position, which then Mr. Msiza ended up being able to apply for and was subsequently appointed to?
Honourable Member, through you, Chair, I'm not certain the number of times the position was advertised. To the best of my knowledge, and if I recall correctly, Chair, the qualification at that particular level was changed and it was dropped to a lower level qualification as approved by the CEO. So that was signed off. There was contention from the office of the CEO that the level of qualification for security specialists at that level was not required. Although we've made recommendations for you to keep because that was in line. Senior management post at the task level 18 had a minimum requirement in terms of the qualifications and experience. That was then a decision was then taken by the office of the CEO to drop and approve the qualification at a lower level. So that I can confirm, Honourable Member.
Right, thank you. That was the last question. This is just my comment because I may not have another chance. A lot of things conspicuously were happening at RAF. And from the picture that is showing before us, is that many of you in senior management played your role. You became both instruments and victims at the same time. And we're not accustoming blame to you necessarily, but we're looking into the systematic effects of this and what we can do to ensure that it's prevented in future. Because the relationship between the former CEO and the specialist security, Mr. Msiza, dates back, like the chair said, to before the time of REF. So these requirements, I put it to you that they were adjusted to suit a particular person. And for that person to then be appointed into the position, which is an unfair practice. And as a human capital person, you would understand that. There were a lot of employees also that were victimized and they were ostracized for different reasons, among others, which could have been believed to be anti-transformation, as alleged by yourself earlier, but who were done badly by the institution and under the auspices and under the administrative capacity of many of you guys who later became victims. And I think these are something that at a professional levels, you guys need to look at, and from ourselves, from a governance point of view as well, look into how we can enhance our processes to ensure that people don't feel like they are closed or they are imprisoned within a particular order in a government entity with such a long hierarchy of reporting. So these are some of the admissions that we would need you guys to be honest about with us and to say, look, we operated under this part of this autocratic kind of a leadership, and we felt like that we needed to implement certain things, but we admit that those things should have not been, so that we can put to record that those who are going to come after you never engage themselves in such practices. Otherwise, thank you for the 20 minutes or so of time of our engagement, and thank you so much, Chair.
Thank you very much.
Thank you very much. Thank you very much, Honorable Madlana. Mr. Barriel, can we have a conversation, the two of us, and let us start where Honorable Madlana left off, and I'd like us to get straight to the point. At the time, that the head of security role, or whatever it's called, national security manager role, is advertised, Mr. Lehumo, who's actually the national security manager, is on suspension, correct?
Chair, I cannot, like I said, it will be difficult for me to match the time frames. I know Mr. Malumi, I know Matumi very well. We've worked together for many years.
Okay, now let me assist you. So his testimony before the committee was that he was on suspension at the time.
Okay.
And therefore he couldn't apply for the role. Are you aware of Mr. Lehumo's qualifications?
I'm not aware
not specifically, but
precise, but I know he has an MBA. I know he has an MBA from Tumenkosa, Chair.
Okay. And that in the end, Mr. Msiza was appointed to the role.
Correct, Chair.
And the requirements for the job were changed in the meantime. When Mr. Lehumo could not apply, the requirements were lowered, and they happened to match Mr. Msiza's own qualification level.
Chair, what I can confirm, I'm not sure about Mr. Msiza's qualification level, but what I do confirm in front of this committee is that the requirements were changed in that particular job profile and were advertised as such to a lower level. So that I can confirm, Chair.
Okay. Yeah, they were changed to a lower level, and Mr. Msiza was subsequently appointed, hence his appearance before us the other day. Was Mr. Msiza interviewed by a panel for the role? Do you know?
Chair, the normal practice is for a panel to sit and do an interview. That is normal practice, Chair. I'm not aware of who sat on the panel for Mr. Msiza.
No, it's fine. I just want to know if there was a panel at this stage. I want to know if there was a panel at this stage.
Normal practice was that there should that was a normal practice to have a panel of doing the interviews for a particular position.
Okay. You do know how this looks in the sense that
indeed,
Mr. Msiza, and let me set it out. Mr. Msiza used to work with Mr. Litswalo at the Road Traffic Management Corporation. When Mr. Litswalo joins PRASA, he then asks for Mr. Msiza to be seconded to PRASA. And Ms. Prudence Mpoma-Nyasha, we'll talk about her just now, is the person who facilitates. You may not know because we're at the Road Accident Fund, but that's since been established through witness testimony for him to come to the Road Accident Fund. And then a request is made once Mr. Litswalo is at the Road Accident Fund to second the same person to the Road Accident Fund, and miraculously sails through the interview because we don't know what other candidates were interviewed, and he becomes a security specialist. And when the role of security manager comes up with higher requirements, it is lowered, and then Mr. Msiza is hired. And this is not speculation. This has now been established as fact. And Mr. Litswalo and Mr. Msiza are business partners. They're co-directors in the same company at the same time. You, as an HR person, if this situation had unfolded in front of you, what would you have thought ethically?
That it's unethical, Chair.
Okay.
Yeah.
All right. Thank you for that. Can I ask, were any of the specialists who subsequently got permanent roles at the Road Accident Fund, were any of them found not to be compliant with the requirements of the job? They all seem to have found the roles that they were looking for. I mean, was any specialist initially seconded to the CEO's office unsuccessful in a subsequent attempt to get a permanent role?
Yeah, I'm not aware of the specialists getting a permanent role, and I don't want to speculate.
Moving from secondment to being an employee of the Road Accident Fund, effectively.
They were appointed as they were subsequently appointed as in an acting capacity.
Can you explain to us the process of appointing someone in an acting capacity? Is there an interview process? Who makes that decision?
It would be the line manager or the executive that makes the decision. For a particular, the role must be vacant, one. Two, the person must meet the requirements of the role. And three, the line executive would then decide in terms of the acting person for that particular position. A submission would then be prepared, and that submission would be approved by the line executive. In terms of the specialist, the CEO would approve that request.
So how were the specialist roles supposed to interact with the line managers who have to perform the same functions? For example, Mr. Modiba comes in as a senior specialist treasury. Mr. Msiza becomes a specialist in the senior security specialist. There's a security manager, and so on. Who's senior between the two? The incumbent manager and the specialist?
Again, Chair, based on your guidance early on, it will be speculation to say to you what was the motive in terms of the CEO.
No. Yes. I'm not asking motive.
Okay.
In terms of giving work instructions, who would give the work instructions to the rest of the staff in that department, in your understanding?
It would be the line manager, Chair.
All right. We heard from Mr. Msiza that he was supposed to help with the restructuring. And he was convening meetings and talking about the restructuring. And as you know, restructuring doesn't go up, it goes down. So when the security specialist is restructuring, it places everybody below them. Wouldn't that be correct?
From the office of the CEO, yes, Chair, that would be correct. In terms of the what they call power of association, and there's also the power that is given to the specialist by the CEO to conduct themselves within the organization, and that may well have been the case where the specialists were given a mandate to do certain things within particular departments. It may have been in conjunction with the senior manager in their department, but there would have been a mandate from the CEO to the specialist, Chair.
So there was a parallel structure effectively, because a specialist might be to advise the CEO, but not to give work instructions to people, because there is a manager there. I mean, that's what, on the face of it, and I'm being generous here, that they advise the chief executive for their interactions with the relevant managers, but they don't give instructions to those people, because you then end up with a parallel structure.
Chair, in the end, it was a parallel structure. So you would have role confusion taking place between your senior management team and the specialists in the office of the CEO. And I can attest, I can confirm that the role of clarification and the confusion did come in from a line management function versus that of the specialist in the office of the CEO.
Okay, so you do understand the difficulties it introduces in terms of accountability and governance, in terms of fiduciary responsibilities up the chain all the way to the board, in that the person with the statutory power isn't making the decisions. It's somebody else who reports elsewhere completely.
Chair, that your view may be correct. Yes, I do understand that, Chair.
Was this ever raised with the chief executive or the board as a problem?
Chair, to my recollection, the board was aware of the specialists in the office of the CEO. And they were aware of the specialists in the office of the CEO.
Okay, I'm going to give the members shortly. I mean, I'm not done, but I see some hands going up. But let me ask you a question. Are you familiar with Section 11.1 of the Road Accident Fund Act? I don't expect you to remember it offhand, so I'm going to read it to you. and that is powers and functions of the board and the procedure. And it says the board shall, subject to the powers of the minister, exercise overall authority and control over the financial position, operation and management of the fund, and may inter alia. It goes on and on and on. And then say, terminate the appointment of any agent and determine the conditions on which such appointment is effected or terminated. That's subsection B. Subsection C says approve the appointment, determination of conditions of employment, and dismissal by the chief executive officer of staff of the fund on management level. Right? A lot of managers have been dismissed from the road accident fund. Do you know if those were ratified by the board, or the rules were changed to allocate that power contrary to the act to the chief executive? Because the act has never been amended in that respect.
I'm not aware. However, I think one must read it in terms of in conjunction with the delegations of power and functions, which I don't have a copy of here with me. In terms of what powers were conferred to the CEO.
Okay, so let me try and assist you.
In terms of the terminations.
Okay, let me try and assist you. Do you recall if any of the procedures were ever changed, delegation of powers from the board to the CEO in respect of dismissals of people?
No, Chair.
You're not aware?
No, I'm not aware.
Delegation of powers and function policies, section 7.1.10 and 7.4.9. There was never a change to that policy as far as you know.
Not as far as I know, Chair.
Okay. I think there was, because what should have arisen is this in your role, is that you not being aware of the change in the delegation of powers. You should have had an expectation that if anybody is to be dismissed, it's got to be ratified by the board. And several managers, senior managers, task level 16 and above people were terminated during that time. Did you ever ask whether these were going to be ratified by the board or not?
No, I didn't, Chair. For me, we operate, in my view, the delegation of authority and functions and powers, and I don't have a copy of it when I speak under correction, allow the CEO to create positions below a certain task level, that is general manager and below, as well as terminations. So for above that, no, I wasn't aware that it needed to be ratified by the board, and I do hear your reading the act and the provisions of the act. That should have been ratified by the board.
Okay, so let me assist you. So the act says here management. It doesn't say executive. It says management level. But then it goes on to say in H, subsection A, it may delegate or assign to the chief executive officer and any member of the staff of the fund any power or duty of the board as it may deem fit, but shall not be divested of any power or duty so delegated or assigned, and may amend or withdraw any decision made by virtue of such delegation or assignment. In other words, the board remains ultimately responsible for this. This is important. And I'll tell you how it links to the money, is that when the board delegates its responsibility in this way, because the act is very thoughtful, it doesn't say every dismissal, it says management level and upwards, right? Because when that power is delegated to the chief executive without any recourse to the board, then it will canvass with the board what the information procedures and the oversight over those delegated powers was, right? It gives somebody in the role of the chief executive absolute power to create an environment in which they cannot be challenged, because they've got the powers of the board without board supervision, which has got profound effect on governance and people's ability to do what Honorable Madlala is saying, which is people being able to register an objection. You understand where that goes, right?
Yeah.
You understand where that goes. So it also links to the expenditure of the funds on hiring Mr. Litswalo's business partner, Mr. Msiza, because that does not go to the board for ratification either. He does it himself. You understand the environment that has been created, right? So
Indeed.
Shall we then canvass this matter a little bit further around the are you aware of the circumstances of in fact the agency that was doing the recruitment of these external specialists? Can you recall who they were and who appointed them?
Chair, I can't remember the name of the agency. That information one would have to obtain from the Road Accident Fund itself in terms of which agency was used at that stage.
Who appointed them?
The agency would have been appointed either through an RFQ, Chair, or through recruitment panel that we went out and tender for.
But you were in the role at the time, were you not?
Yes. So the agency would have been appointed through our SCM process as one of the panel members to oversee or to manage the recruitment on our behalf.
No, sure, but I mean, you don't need to remember specifically who they are. We can ask the Road Accident Fund, but I would expect that you are the person through which all of this happens because of your role. Or were you bypassed?
In terms of the appointing the service provider, let me just understand that.
Someone has to, so this is how it normally works, and I'm sure you'll agree that the head of HR or the relevant HR manager will be asked to achieve a certain objective. We're looking for senior specialists in this role to assist the chief executive officer, etc., make it happen. You know the rules. You will speak to SCM and they will find you somebody. You will then explain to that agency that at the time is either on the panel or whichever mechanism, what it is exactly that is needed, what the requirements are. You will know who is going to be on the interviewing panel in the event that there is an interviewing panel, etc., so that you are able to report up the line in terms of progress and where you are. I would expect you to know that procedure. So that's why I'm asking the question.
Indeed, that is a procedure, Chair. I would know.
But you don't recall.
I don't recall the agency, Chair.
No, it's fine. The agencies we can establish. The question I'm asking is, do you recall driving that process?
Yes, together with the recruitment department, we drove that particular process. We gave the brief to the agency that these are the specialists that we require within the fund with a job profile. And drafting of the particular advert and the advertisement of the particular advert. The agency would then source suitable applicants for those particular positions, and a panel will be constituted around who the interview panel will be to interview those applicants.
Was that process followed in the case of all the specialists?
It was followed in case of all the specialists. There may have been, it was followed, Chair. That I can guarantee from a process perspective, that I can guarantee the committee.
Let me ask a specific question. Did you or the agency or anyone involved in the process, to your knowledge, receive an instruction from Mr. Litswalo or anyone in his office to secure specifically these three people? Mr. Msiza, Mr. Modiba, and Ms. Manyasha.
Okay.
Because the two people at least we know, they had a previous professional relationship. We also now know that Mr. Msiza was also Mr. Litswalo's business partner. And somehow he ends up being the best candidate, and a whole bunch of adjustments are made to the system to get him to be National Security Manager later on. Can you tell the committee for certain that, to the best of your knowledge, there was never an instruction or any interference whatsoever? This was all coincidence.
Chair, there was no direct interference. However, Chair, I must qualify this, that the Office of the CEO, we would declare which agency we're going to use in terms of and where people can submit their CVs to. So, Chair, this was shared with the Office of the CEO.
Okay.
That
who did you share
the
it
people
with?
Can apply to this particular agency. Second, Chair.
Who did you share it in the Office of the CEO? We want a person's name.
It would be Ms. Mpo Manyasha.
Mpo Manyasha.
Yes, Chair.
But for her own recruitment, so she had been seconded basically from the Department of Transport. So she came in by secondment.
Yes.
Then an agency went on recruitment and they recruited her.
No, not for her specifically. She was, as you said, she was seconded from the Department of Transport. Her position in the office of the CEO as head of this was then advertised. And there was a recruitment process followed in that instance. I am referring to the 7 specialists. There was.
I see. Okay, so basically she knew which agency it was.
Quite correct, yes.
Okay, we will canvass what happened between her potentially and the agency with her when we see her. I've got a few other questions, but let me give Honorable Neil May an opportunity to ask some questions. Please go ahead, Honorable Neil May.
No, thank you, Chairperson. And the questions that I have in front of me, I have a list of particular professional services for HR as experts. Looking at the 31st of the 10th, 2023, a deviation for 8 million rand for HR recruitment costs. And that was to a company called People Perfect Pty Limited. Can you recall that?
Honorable May, no, I can't recall that offhand.
Because as the head of HR, and I come from local government and finance, normally you would request the deviation if you are for that, specifically if you are the head of HR. Then we go down. We worked out there was tenders to the amount of 730 million. And they were all for professional services, HR experts. You're looking at Molefe, Lepu Incorporated, 5 million. Then you look at Buthelezi, Vilakazi, 5 million. Ranko, which is, excuse my pronunciation, 5 million. Molefe again, 5 million. So it looks as though those were split. Then you come down to Giale Mogashio, and then you come down to Mashiani Moodley. Now, Mashiani Moodley is 33 million for professional services HR experts. You then carry on here to Non-Dumiso Vui, and that is for 6 million. So these were all HR tenders. Now, being the head of HR, you would know what worked because you as HODs would sit together, you would know what your plans are. And this is a huge amount of money, 730 million. And that's not taking into account the wellness program, which was on the 1st of the 9th, 2020 for 16 million. So 730 million were the amounts that were tendered for from these various companies. And then you look at what we've heard today, that you were restructuring, and that was through another company. So what were all these professional services HR experts employed to do? Because most of them are on the 1st of the 12th, 2023, 1st of the 12th, 2023, 1st of the 12th, 2023, 1st. And that seems to be a tender that was split 5, 10, 15, 20, which is most interesting. I think we know that, one can't split tenders, professional services, HR experts. The same, 1st of the 12th, 2023. So 1, 2, 3, 4, 5, 6 companies were procured for professional services, HR experts during that time. Can you enlighten us? The same with Nondamiso, 1st of the 12th, 2023. Thank you.
Through you, Chair, Honourable Member, I'm not aware of those contracts in detail. So I'm unable to respond to the assertion or allegation that I was supposed to know. I do not know about those contracts that you've just mentioned. I don't have the detail in front of me. I do not know if it was from a panel of ER perspective or recruitment or wellness or HR related services. I do not have the details, so I'm unable to respond to that question, Honourable May. Thank you.
Follow-up, Chair, because I'd like this information to be sent to us to actually find out what work did they actually do. If you were their head, it was obviously an open tender that went out, and it was a large amount. It was about 730 million, minus the 8 million of perfect people for recruitment. That would definitely have been something that you would have known about, being the head of HR. The last question I have, during the time that you said that you were unemployed, and then now recently you have been employed, did you do any consultancy work for any company? Whereas, because you weren't formally employed and a year is a very long time to sit at home. Did you do any consultancy work for any companies during that time? Thank you.
Honourable May, through you, Chair, no, I did not do any consulting work.
And last question. So for that year, you were being unemployed. You had no income, nothing, other than a pension or a payout, because 1 year is a very long time to sit at home. Thank you, Chair.
That is correct, Honourable May. I was unemployed with no income.
All right. Thanks very much, Honourable Nilmay. Okay, so I think where the people in any of the specialist roles, in the corresponding specialist roles, suspended subsequent to the introduction of the specialists, and then the specialist subsequently took over that role in an acting capacity?
Chair, I can only, to the best of my recollection, I can think of the CIO, where specialist was appointed as an actor in that particular role, the chief technology officer or the chief information officer. So when that position became vacant, there was a specialist that took over in an acting capacity into that position. That is about the only role I can think of at this stage. The other one was the specialist that took over as CFO following the Mr. Sanguela, when he was asked to step down as the acting CFO, that she took over. And those are the only two particular roles I can recall, Chair, where where specialists took over the acting arrangements in a higher position.
What about security with Mr. Lehumo and Mr. Msiza?
As I said, Chair, the security, Mr. Msiza came in as a secondee, as a specialist.
Yeah.
And he was then appointed through a particular process, as we've examined earlier on.
Who took over from Mr. Lehumo when he was suspended?
When he was in the office of the CEO, because remember, security reported to the office of the CEO. So I would assume that Mr. Msiza took over the responsibilities of the particular of that particular function.
So that would be the third one.
Yes.
Okay. So there's a pattern emerging. So can we just talk about the practice of ER pursuing charges without the line manager? And we'll start with Ms. Mthethwa's testimony that ER went on to pursue disciplinary charges against claims administrators without her concurrence as a manager. That was her testimony. Would she have misled us in that respect?
Yeah, I can't attest to that. The point is, ER would never pursue charges against an employee without the involvement of the line manager.
No, sure. There's involvement. There is whether the manager is concurring or not, that the employee needs to be charged.
There would not be an insistence from an employee relations department to charge the employee, Jay.
Are you familiar with somebody called Walter Ramaswi?
Yes, Walter. Yes.
You are?
Yes, I am,
okay.
Jay.
Mr. Walter Ramaswi sends an email on the 25th of May 2021. It's a long time ago, but he does, and he sends it to several people, to somebody called Tapelo Maluleke, Princess Shabangu, Richard Machete, Bryson Tsetlo, Motluding Letswalo, and copies Jimmy Mamadisa and Sakile Gabuza. You know any of those people?
Yes, I know all of them, Chair.
Let me read the email. Please note email below from Ian. That would be you. Yes. Based on that, I've indicated that after finalizing the charge sheets for this week, I will be in Joburg on Thursday to identify another 5 people. On Friday, I will be in Menlyn to do the same. So may I please be excused from being part of the DC hearings, as I will be preparing for the next round. Tapelo and Jabulani, please start identifying the next 5 employees to be charged. And one of the things that Ms. Mthethwa shared with us was that there appeared to have been a prior decision to just suspend people without reason and then find the reasons later. And that email would appear to point to something like that. Why would people need to be identified for suspension if an investigation had already taken place? You know who those people are. And that email came from you.
Yeah, Walter wrote the email. If I'm correct, he mentions me in the email.
Yeah, referring to an email from to an instruction from you.
That
you recall having a conversation about finding people to be suspended.
No, Jay, it was not about finding people to be suspended. This relates to the 180 days. Where line managers and claims managers in the claims department needed, because there was default judgments that happened, and these with the former claims chief claims officer. Those people would need to be identified. There would need to be a process of understanding with the line manager what actually transpired with the 180 days and why these people did not adhere to the procedure as laid out. So it was never as it appears in front of you that there was an instruction from myself to go and find these people. There was a list of people that did not adhere to the process and procedure for the 180 days that resulted in default judgments.
Your answer would assist
we then assisted the managers to draft charges for these people to go through a particular process.
Was there an agreement to do it in batches of 5? What is the reference to 5 people at a time?
No, there was no.
You either have 20 or 23 people that fall in that category. You identify all of them and you deal with them. What is this business about 5 people here and 5 people over there, when there might actually be 9 people in that same office?
Because we didn't have the capacity at that stage, Chair. So the point was that we'll do it in stages, in terms of going through the list for each particular region, to investigate and to then determine the wrongdoing on the part of the employer, if any was found. So it wasn't particular to 5 people.
Okay, so I'm gonna give after this question, I'm going to give Honorable Gobega an opportunity to ask questions. But Ms. Mthethwa's testimony before us was that she looked into this 180 days matter, and she set out the reasons why these matters fell off the bus, and it was more complex. It was linked to the cancellation of the panel of attorneys. There not being somebody to handle the matter. Sometimes it would be required in court, etc., etc. It wasn't their fault. And those people were nonetheless subsequently suspended. This is why, so when I was asking you about the concurrence of the manager, is because we have a history that we were given, a context that we were given by Ms. Mthethwa, and that's why I was asking you whether it would be true that such happened. So the manager says, I know why these cases have exceeded these days. Mr. Brian, I forget his surname. I keep forgetting his surname. He also confirms that this was a systemic problem as a result of several terminations, panel of attorneys, panel of medical experts, attorneys not getting the file until the morning, not knowing what pleadings to do in court, etc. You are aware of that situation, aren't you?
Yes, I am, Chair.
And people were nonetheless. Yes, so there were systematic problems. And she said these suspensions related to that kind of problem, and therefore she disagreed that those people need to be suspended, because what then follows is what you told us earlier about the fact that the Road Accident Fund was using lawyers throughout. And I'm going to walk you through in detail so that you can assist us in terms of how this entails. But what's apparent on the face of it here is that somebody elsewhere has taken a decision that action must be taken against people, against the observations and the judgment of the line manager. And you had told us earlier that that never happened.
That decision emanated from the office of the CEO, the chief claims officer, the acting chief claims officer at the time, in terms of default judgments, that action needs to be taken, or there needs to be consequence investigation against the people that have transgressed around not settling claims within or not doing the payments within the 180 days as determined by the courts at that stage.
Okay, so what subsequently happened to those people? So we now know that an instruction came from the office of the CEO. What subsequently happened to those people? Were any of those people found to not be culpable and therefore were not suspended at all?
Chair, I can't recall the detail, but those people went through a process. I can't recall what the outcome was.
Were they suspended first?
Chair, I can't recall if they were suspended. What I do know is that they went through a disciplinary process.
According to Ms. Mthethwa, they were suspended.
Then one would accept that then they were suspended, Chair.
Do you see how this bypasses the line manager?
The line manager would most probably be under pressure, Chair. to agree yes, I can see this, but the line manager, it cannot be because your ER people does not understand the intricacies of the claim system. It would need the involvement of the line manager to determine the veracity of the negligence on the part of a claims handler.
No, but in this case, Ms. Mtetwa says that there's no veracity to it and the people are nonetheless suspended. That's what I mean by bypassing. So to the extent that the line manager is now agreed, they're doing it under duress against their better judgment, which goes to what the Honorable Madlala was asking about management being able to push back. But what we hear from you now is that there would be an instruction from up on high for people somewhere in the weeds there to be suspended, despite the judgment of their line manager in terms of what the problem actually is.
That would be the case, Chair.
Okay, let's just talk briefly about the law firms. So which law firms would you use for these, in most cases, for disciplinary hearings and disciplinary procedures at the Road Accident Fund? There are three in particular. We've received the list. I'm just trying to establish if your recollection is the same as our observation.
Chair, I wouldn't be able to name the three, but I do know these three were allocated from our legal department to the ER department.
Okay, so you would never get sight of which law firms were used for these cases?
No, Chair.
Okay, that's fine. So who chose the law firms? Was it the legal department?
The legal department would allocate those law firms to ER.
Did you ever have lawyers present in internal hearings at all?
In internal hearings, yes, Chair. There may have been from a perspective of the chairperson being the attorney.
And those attorneys would get paid?
They would get paid, yes.
Did any of those attorneys that provided those presiding roles ever go and argue cases for you for the Road Accident Fund outside, even if it's not the same case? Were they limited in terms of what they could do for the Road Accident Fund?
Chair, that would fall outside my ambit. I would not be able to answer that particular question.
All right. So you hired attorneys to preside over internal hearings, the Road Accident Fund, that is. At the CCMA?
Yeah, the CCMA, yes, Chair.
You'd have legal representation because you're not presiding.
If legal representation was allowed in an arbitration case, we would then have a legal representative there. So that if the commissioner, yeah.
I note in your answer that you say if it was allowed, which means that was your default position to have a lawyer there.
The case would normally first be handled by your ER manager, your ER consultant. If it's a complex case, we would then appoint an attorney to manage a particular ER matter for us.
Okay, would you have counsel sometimes? Would you have counsel sometimes, counsel and advocate in CCMA hearings?
If it is requested by the attorney, Chair, that would normally be arrangement between the attorney and the senior counsel via our legal office.
Isn't this heavy-handed in terms of cost and in terms of process? How many employers have senior counsel at a CCMA hearing? In your experience?
I cannot confidently say that. I know that we used to use senior counsel from our attorneys if there was a complex matter. Mostly for the labor court, not the CCMA, Chair. Okay. The CCMA we would have a legal representative appointed to manage the particular case at the CCMA. When it comes to labor court matters, that is where we would involve senior counsel.
And finally, let me ask this: who would insist that employees be not reinstated? Let me tell you a story that we've received, because also money was expended by the Road Accident Fund. Ms. Zamaswazi Flope from Durban was dismissed for insolence. And we'll talk about insolence insolence being the basis for charging people at the Road Accident Fund in context, because it appears to have happened on more than one occasion to be conservative. Ms. Zama Flope wins her case at the CCMA. The Road Accident Fund is represented by a phalanx of lawyers. She wins nonetheless. She goes to the labor court. She wins. The Road Accident Fund goes to the labor court. She wins. The Road Accident Fund goes to the labor appeal court. She wins. A reinstatement is ordered by the court. The Road Accident Fund ignores it. Ms. Mtetra is then forced to go back to the labor appeal court to ask for an enforcement order. She obtains it. The Road Accident Fund ignores it. Who has the power at the Road Accident Fund to instruct an employee somewhere to defy the labor appeal court in that way and spend state resources to fight a case that clearly isn't there? What would happen in cases like that, where a case has progressed so high?
That permission would normally have been obtained from the office of the CEO, Chair.
To do something like that?
Yes.
Because as I speak to you now, there is still a second enforcement order on that case. In the Victor Songelwa case, that was also the same. And he got paid serious money to sit at home. Yeah. Honorable Kubeka?
It's Matuna, Chair.
Yes.
No, thanks, Chair. Shortly, I want to check in the matter that you are just asking the witness. I want to check, given that at the time he was heading there, what did he give any advice in relation to this matter, to the CFO, to the CEO? Sorry, because that's what I would.
Which matter?
The matter of the lady from Devon.
Are you aware of that case, Mr. Barriel?
Chair, not the particulars of the matter, but so once ER is finished with a particular process, and once it hits the labor court, it becomes a legal matter, and it will be under the administration of our legal department.
Do they never come back to you to say we've lost the case and take new instruction?
No. They will go directly to the chief governance officer or the CEO, Chair.
Okay, that assists me. So to Honorable Maduna's question, you then wouldn't know.
Correct, Chair.
Why does it work like that? I mean, you're the head of. I mean, that seems highly unusual.
Chair.
Yes, ma'am. I'm gonna come to you now. This is my last question for now.
Chair, that was the arrangement that the legal department will then take over the particular matter and call us in from an ER perspective if assistance is required or clarification is required. They would then deal with the attorneys and the senior counsel directly, or the law firm handling the particular matter.
Yeah, but I'm asking why wouldn't when the case has concluded one way or another, why wouldn't you be informed? Given that further litigation and public money spent on a hopeless case needed to happen. That's what I'm not understanding.
Chair, there may be feedback through human capital in terms of the progress of the particular matter, but the instruction to take the matter on review to the next level of court, that would come from the legal department and the CEO.
All right. Okay. So I want to be fair to Honorable Kubeka because your hand was up first, sir, and you haven't asked a question before. Honorable Kubeka.
Yes, thank you, Chair. And greetings to the House, greetings to honorable members, greetings to the team supporting SCOPA, and greetings, Chair, to Mr. Barriel. Mr. B, first and foremost, I'm just going to ask you a very general question that is not necessarily linked directly to your portfolio. And I'll ask this given that you've spent over 10, I'm sure almost 15 years at RAF from my understanding. That in your personal view, what were the three biggest issues that were or are crippling RAF right now? Because the Road Accident Fund seems to be a huge disaster as a whole, as an entity. According to you, just the top 3 issues that you would argue as these are the biggest problems at the Road Accident Fund. And Chair, may I request to switch off my camera for now for bandwidth?
You know, Honorable Kupega, our viewings go up when you're on camera, but it's fine. You can switch it off. It's fine.
I wish, Chair. Thank you.
It's fine.
If I may proceed, Chair, the honourable member asked me what I think the 3 biggest problems are issues are at the Road Accident Fund. One would be the inefficiency around the technology. 2 would be the legislation. And 3 would be the funding model, Chair. So that, in my view, are the 3 major issues currently at the Road Accident Fund.
Mr. Perry, when you say legislation, what legislation are you talking about specifically? When you say funding, could you elaborate on that one too? I'm very interested in those.
Legislation relating around the law of delict. In terms of that's the one. Second is the payment in installments, that there's lump sum payments, and the net inflows versus the net outflows from a financial perspective. That the net outflows exceed the net inflows from the petrol levy.
Oh, okay, thank you. So basically what you would recommend to put, for instance, the Portfolio Committee of Transport would be for the legislation around those issues to be looked at. Issues with the legislation itself, issues with the funding model versus, like, for instance, your inflows versus your outflows. Would that be one of your main recommendations to this committee and transport?
Indeed, honourable member.
Okay, and then the technology part that you speak of, could you elaborate that just shortly, briefly?
Technology part is the management of the claims administration and how technology can enable the administration of a claim from a digitization point of view and administration point of view.
Okay, no, thank you. That is noted. I think, Mr. Barriel, I noticed here that since 2020, over 130 employees between 2020 and 2024, I believe, that over 130 employees of the Road Accident Fund have been suspended with various, some have outcomes to their suspensions, some don't have outcomes to their suspensions. I think in any organization, and I'm not, the first question here would be, in any organization, that seems rather high, but I wanted to know, what is the team or staff complement at RAF versus the suspensions that we're looking at? Because these look rather high. What numbers are we looking at in terms of the staff complement at the Road Accident Fund?
Thank you. If my last recollection of the staff complement was about 3,000 employees. I do agree and I concur with you, honourable member, that the suspensions of 130 is high.
And what would be the cause of that, according to you? I think, and I'm asking this to you because you were sitting at the head and you were looking down on everything that was happening. What was the cause of this? Because you see, I think if I go back to the previous conversation that Honourable Chair just had with you, in some instances it seems as though some people were being purged at the Road Accident Fund, and now with the irregularly high number of suspensions and the I would say the allegation that there's people who are being purged, those two would make sense given the very high numbers here. Could you speak to us about that?
Honourable Member, like I said, I concur with you that the suspensions are high. And it may have been a lack in terms of effectively managing those particular suspensions or bringing it to conclusion. I may also then agree with you that in the current environment, suspensions may be the order of the day, and it certainly appears like that, having, as you alluded to, 130 employees on suspension. The reasons for that may vary, Honourable Member. It talks to, like the chair alluded to, governance and the implementation of that governance within the organization. That is my comment on that, Honourable Member.
Okay, noted. I think I just want to also know, have these people been replaced by acting people in these positions? Bulk of them was, and I'm asking this specifically because I'm trying to assess the cost implications of having either people acting and getting acting allowances in those positions, and the people who have been put on indefinite suspensions. Have those people been replaced? What is the story there?
Honourable Member, being mindful that I've left the RAF in March 2024, I wouldn't know the current status. But normal practice would be that if you are suspended, that somebody needs to act and do the work in that particular position. So it would be a costly exercise then, apart just from the suspensions, but also having somebody to act and the vacuum it creates at a lower level. It then becomes astronomically expensive in terms and the knock-on effect of the suspensions within the organization and the financial burden it will then place on the organization. So yes, there would be a knock-on effect.
Okay. Now you see, I'm asking. The reason I was asking this is because I see some people here earning. They've got disciplinary hearings in progress and have been suspended since August 23rd, 2021, at a salary of around 6.5 million rands, 5.1 million, 1.9 million, 1.9 million, 2.6 million, 2 million, 4 million. Would that not be something that you as a head at the time try to curb? Because I'm not sure if it falls under fruitless and wasteful or irregular expenditure. Would that not be part of something that you would have to try and curb as the manager of that department? Because it looks as though as much as you may be paying salaries, there's a lot of salaries that were being paid that ought not to be paid.
Honourable Member, I'm unsure of the salary levels, 6.2 and 5.1 million. However, it would be a concern in terms of the suspensions, the time and period of the suspensions, and as you've alluded to, the expenditure from a human capital perspective. It was a concern.
So, as much as it may, you saw it and you agree that it was a concern. What did you do about it?
Under the circumstances, there wasn't much one can do about it, Honourable Member. These suspensions occurred, the point is that there was not much one could achieve or do about it.
Please explain, sir. I'm trying to understand. I think that the reason I'm asking all of this now, this here and where I am now, is I'm trying to understand the delays. What's with the delays? What delayed these processes for so long that you couldn't intervene yourself and say, hey, listen, guys, we need to conclude this thing. These people are costing the company too much. What was with the delay, and what would stop you from intervening in the process and making sure that these processes are concluded timely?
Honourable Member, as I've said, that most of these matters required the assistance of legal professionals. Seeing that we had a legal panel or labor legal panel that we sourced from our legal department, so that inflated the cost and exacerbated the cost around the suspensions itself. As you ask me, what did I do about it? There isn't much I could do about it. These suspensions were from a legal point of view, if it was a legal matter handled by the legal department, but obviously one would endeavor to motivate the team to resolve or to bring these particular matters to a close as soon as possible.
And did you endeavor to do that?
These were quite evident and raised at the EXCO level in terms of the number of suspensions we had, Honourable Member.
And the EXCO didn't assist you in that regard, I take it?
Noted, yes.
Yes, what, sir?
There was no assistance. There was no assistance from an EXCO level in terms of dealing with this particular, the exorbitant cost around suspensions.
Oh, okay. I think just lastly, Chair, I noticed that along with these it's around 136 employees of the RAF that have been suspended since around 2020. Many of them fall in the task bar 10 and lower. Now, at 10 and lower, these are the guys, excuse me, who are earning not as much as your high-level guys in task 15 and 18. The task 18 would be the 6.5 million per year salary. The task 15 would be the 5.1 million salary. And the task 13 would be a 4.4 million salary. The guys at task 10 would be the guys earning possibly R1 million or less. So the middle to lower managers, they're at the road accident fund, I guess, because you guys have got some seriously healthy remuneration packages. Now, the question there is, in your personal view, the guys that were at task 10 and lower, they were in most cases found guilty or dismissed. And the guys who at above task 10 and above, there was a lot of difficulty in concluding their hearings. According to you, what would the reason behind that be? And I think to you, Chair, that would be my final question, and I thank your indulgence, gentlemen.
Thank you, sir.
Honourable Member, I did not do an analysis of that. However, the salaries that you're mentioning sounds a bit exorbitant at the top level, but one may then speculate and assume that that the higher earners may be able to afford legal representation as opposed to your lower levels employees. But I cannot confidently answer that particular because I did not do an analysis of that in terms of the task grade per level being on a suspension or being dismissed at the time. In fact, it is almost a year ago. So yeah, I haven't seen the updated numbers for quite some time. Thank you, Honourable Member.
All right, thank you very much. Honourable Madlala, I saw your hand, and then I'll come to Honourable Skosana. They came in that sequence.
No, Chair, I'll pass. Thank you. I've been covered by other colleagues. Yeah.
Okay, Honourable Skosana, I also saw your hand. Please go ahead.
Good morning, Chair. Good morning, colleagues. I'm not sure whether... Yeah, I hope I'm not going to off-ramp because I think Honourable Gubega has covered a lot of issues. And I think I must switch off as well. Do you mind if I switch off, Chair? Or is it fine?
Noted.
Or is it fine?
Noted. I can't say no, given that I've allowed everyone else.
Yeah, no. I'm just asking if it's okay. You know.
No, please
okay.
do. Please, you can switch off. It's better for bandwidth.
No, but I think it's better to be, you know, with my camouflage, as you said, that it will increase numbers. You know, Gupera, I know you wanted him because he was not on camouflage. Yeah, Jim. You know, I've been looking at the chart here. I'm not sure whether, I'm not going to go into the issue of suspension and other issues which were sent, but I was very concerned of seeing what is highlighted here. Can I raise those issues, Chair? Hello?
Honorable Skosana, you froze, so I couldn't hear the last of what you said.
Yeah, hence I've switched off the video. Maybe that's a problem as well. And there's
Yeah.
Now, I wanted to touch on the chart which were sent here. You know, there's figures which are scary. Can I do that, Chair?
Yes, of course.
Yeah.
Just explain what the figures are.
Yeah, what I've seen. I mean, he mentioned the issue when Honorable Gupega was asking about him. He was saying the issue of which is the biggest concern for him was the issue. Let me put it. You know, let me put it like this. I think I've seen the expense of the technology, because they were talking about technology. You know, they're spending a lot of money on technology. So I don't know why do they still have a problem on that. But I'm looking at the chart here. I'm seeing companies, you know, these Artemis, you know, Diale, Mukhwacho, Mashiane, Mudli, and Munama, Mulife Dlepu Incorporated, you know, Buthelezi, Vilagazi. But I'm a bit worried, as I've been worried in our meeting. You know, I've raised these issues, and I think I'll start with that one. I'll end up with the media mix. I don't see the big law firms here. Do you have any big law firms when you were still there? Because the contract are still running, you know, and I think by then you were still an employee as well with RAF. Is this the only law firms which you have, which are highlighted here, or you have others?
Honorable members, Khosana, as I've alluded to, the law firms on panel that is allocated to ER matters is managed by our legal department, the governance and legal department. So they would allocate a law firm or an attorney to the ER department from their particular panel. So ER does not currently have or did not have its own panel. The panel was, the legal panel was used for ER matters.
Now, hence I'm asking, I understand that is a legal issue. It's a legal people who are dealing with this. But my question is, because I'm saying I don't see big law firms here. Or they are only allocating these ones in particular.
I wouldn't be able to speculate on that, Honorable Skosana. Why that, in your assessment, that only the three are allocated to ER. It may be that those are the only three on the panel that deals with labor related matters. Or that responded to the labor-related matters during the tender, and that is why these three are used for labor matters.
Okay.
Honorable Skosana, I'll stop the clock. May I assist a little bit in terms of what we requested from the Road Accident Fund? Okay, so we requested two categories. One, any contract from 5 million rand and above. That list is in the memory stick of the members. I just can't remember the specific file. And anyone, whether they are a law firm or not, who is 5 million and above would then be listed. But we also asked the Road Accident Fund to provide us with a list of their legal expenses. So the panel of attorneys that the Road Accident Fund uses are generally not what you call the big law firms, in my observation, right? There is a separate list, and you might not have been in the meeting, but all the members were furnished with, when the legal team was there, the head of the litigation in Gauteng was there. The members were furnished with a long list of law firms that represent claimants or that have been to court with the Road Accident Fund and how much they've been paid over the years. That's a separate category. So I'm just trying to clarify that, because Mr. Barriel wouldn't have access to that information. The members do. But that's how we asked for the information from the Road Accident Fund. And what you're looking at is probably the list of contracts 5 million and above. And
in fact,
law firms.
Yeah, in fact, because it's not only law firms, there's other
yes.
IT. Now, my question, in our meetings, we had your discoveries. We had issues with the companies like the discoveries, which as well, their contracts are over 5 million rand. And on this chart, I don't see any. I see, as I've raised the issue of a media mix. There's media mixers here, which is not a law firm, and there's other companies like your Vodacom, your Amazon, your property management. Yes. Now,
let me just explain. So Discovery was never a contractor of the Road Accident Fund. They are an external party that is suing the Road Accident Fund because they believe the Road Accident Fund should cover medical expenses. So they won't appear on that list. They are an external party that is suing the Road Accident Fund, and their matter is in court. So they won't be on that list. Yeah.
So REF never paid them anything as they are being sued.
No. They didn't. So basically, the Discovery come in because some of Discovery's members get into a road accident fund. The question is whether the medical aid or the RAF should cover those medical expenses. So the RAF hasn't had a reason to pay them anything. They are simply in a legal dispute between them.
I understand that, Chair. So I understand when you say there's no cent paid to those, hence they are not here. I'm happy with that answer. The issue which I've raised in a meeting, if you remember, Chair, I'm seeing Media Mix is already paid 403 million rand.
Yes.
And remember, the lady, when he spoke to us, he said because of discount, remember that? That story when I asked, yes. Now you look at the contract. The contract was signed the contract ends in, I think, 2027
November.
Yeah. It started on 2022. There are 3 years now. Already 403 million has been paid. Is it value for money?
So Honorable Skosana, so let me try and protect Mr. Barriel. So Mr. Barriel is here to deal with HR matters only. We are still going to get the people who are going to come and talk about Media Mix 360 when the CFO, who's head of procurement, also by virtue of a job, comes to our committee to testify. So he's dealing with HR matters, and to the extent that lawyers are involved, it's because of the suspensions and the cases and the use of attorneys, etc.
Thank you, Chair.
All right, thanks. Go ahead, Honorable Skosan.
No, I'm fine, Chair. Thank you.
Okay, you're covered. Okay, all right. Okay. Mr. Barriel, I want us to be able to release you shortly, and also the members. So I just need to cover a couple of matters. I will just be certain that we have covered the right ground. I think in the earlier part of our conversation, we've heard from you that there was a HR, let me say HR because that's the term that everybody understands, basically had to help to remedy a situation where the panel of attorneys had already been terminated, to try and make sure that there's recruitment of state attorneys and so on in order to assist to cover the ground. But this was not something you could have done before the decision because you were not asked to participate in the planning for that decision. Would that be correct? I just want us to put it to bed and not come back to it again.
That is correct, Chairperson.
Okay. You've also confirmed in our earlier conversation that it is indeed true that the people that worked in origination, in other words, were out there in rural hospitals and the like, were reassigned elsewhere because there was a decision taken not to actively encourage direct claims. It doesn't mean they were blocked off, but they were not to be actively encouraged to take place. And as a result, those people were reassigned to other roles.
Correct, Chairperson.
Okay, so we can park that and put it aside. Then we've discussed the issue of the consultants that came in, the issues of the conflict of interest, and the process of recruitment and who made which decisions. I'm satisfied in terms of the answers that you've provided in that respect. I don't know if you've got anything to highlight, but if not, then we can park it and move on.
Nothing to add. Thank you, Chairperson.
Okay, so that's the third on our list. And then we wanted to find out about the suspensions and particularly the litigation of matters, because we also want to ask the relevant people. So what you've said is once a matter is handed over to the legal department, and I really want you to be certain about this, once a matter is handed over to the legal department, then the legal department deals with it. When the case is concluded, and forgive me for asking this question again, is for clarity and certainty so we can move on. They come back and report to you on the verdict of the case. Let's say it's now at the labor court. They come back and report to you.
That is correct, Chairperson. They would give us, they would be that update.
The decision to appeal, who makes that decision? Either to go to the labor court from CCMA or from CCMA to the labor court and labor appeal court?
That will fall in the ambit of the legal department, Chairperson, in consultation with the CEO.
Okay. Oh, all right. So basically, that's something that needed CEO authorization, and therefore, to the extent that there are any court orders that were defied, we would need to ask the office of the CEO. Sorry.
Excuse me, Chair. Apologies. Could Mr. Barriel repeat what he just said now?
Okay, just repeat what you've just said.
For any review or appeal, it needed to go to the legal department, the head of legal, which is the governance legal, as well as the CEO to approve taking a matter on appeal. That is what I said, Honorable Chairperson.
Okay, Chair, I'm asking because I think I'm trying to understand the same thing that Chair is trying to understand here, that if the people who are directly involved in the process and the line managers are responsible for that are not involved, how are they not involved in the appeals process? I think that's more or less what I'm trying to figure out. And I think, Chair, that's, if I'm not mistaken, that's along the same lines you're going to. Thank you, Chair.
Yeah, no, we were going along the same lines. It seems odd to me that the head of HR wouldn't have a say in what then. I would normally, even if the CEO, I would expect the CEO to have the legal person and the HR person here in the room and say, guys, what do we do? What do we do? Do we proceed or do we leave this and just reinstate the employee? That for me appears to be a sort of the regular expectation that you would have. So we've dealt with that. I just want us to briefly just ascertain now where it comes to the claims handlers, because this is why the claims handlers issue. We're not, as you've noticed, we're not necessarily asking why was this an outcome in a particular case. The claims originators are important to us because if people are not able to claim directly, they end up going to a lawyer. And the committee generally, and I think I speak on behalf of all of us, generally we want people to have a hassle-free process where you really go to a lawyer if you must. Otherwise, you can work with the road accident fund and you get a fair outcome and it covers you. So that's the interest of the committee. It seems cheaper and it seems less traumatic for the claimants. And that's why we have an interest. So let me declare that upfront. Similarly with the claims handlers, because this is where we are concerned, Mr. Barriel, because it's got financial implications for the RAF in terms of the court orders and so on. There's over 430,000 outstanding claims. That number is not going down. So when we see that the capacity at the claims administrator level, so at the litigation level and at the claims administrator level, the capacity is dropping, then you expect that lots of claims would be outstanding, which forces people to go to a lawyer, get a court order. You see where I'm going. So the interest of the committee generally is a hassle-free process where the RAF works efficiently and we can only bring the lawyers when they need to be involved, otherwise leave them out, right? That's why we are harping on this issue. And the testimony we've received is that well over 100 claims handlers were suspended. And when you see emails that says 5 people here, 5 people here, it doesn't make sense to us because it's got a direct implications on the operations of the road accident fund. But you can confirm that claims handlers. Do you have an idea of how many in total claims handlers, stroke administrators were then disciplined because of the 180-day issue?
Chair, I do not have a definitive answer to that in terms of the numbers.
Okay. And then just the attorneys, I really just want to be certain that the road accident fund would not have lawyers prosecuting an internal case.
Chair, normally the attorneys appointed for internal matter would be the chairpersons of a disciplinary hearing, a formal disciplinary hearing.
Right. Was there ever an investigation in your time into the conduct of the ER department?
Chair, there was recently, and I think it was Bowman that was appointed to do an investigation around allegations in the ER department. I'm not sure what the outcome of that particular matter or the investigation was, Chair. But there was allegations against the certain members within the ER department,
right,
and against the senior manager in the ER department.
Was that in your time, or when the investigation started? Was that in your time or after?
In my time, Chair. I think it was just at the cusp of that particular period.
Okay. All right. So who commissioned the investigation?
It would have been once there is an allegation of that nature, Chair. The Chief Human Capital Officer would then consult with the legal department or to appoint a service provider to conduct such an investigation. So I commissioned that particular investigation into the ER department to ensure that everybody's treated fairly and transparently, even if it's from an ER department perspective, Chair.
Okay, but you left before it could be concluded.
Yes, Chair.
Okay, now we will pursue that. This is important because if the ER department was behaving inappropriately, then they would litigate. So somehow, one would understand why they would keep appealing and use attorneys appeal all the way, and they would, ignore court orders and that kind of thing, which is an unnecessary expense from my perspective anyway. I mean, if somebody has done something wrong, of course, hold them accountable. But if the process says they haven't, just reinstate them and move on, and reintegrate them into the organization and move on. I think you and I can agree on that as a general principle, that it's important that we try and do that in organizations. So no, I'm not far from the end. I just want to be sure that I've covered everything. So I'm just covering my notes here. Okay, we've dealt with the ICMS. So we've agreed that the ICMS process and the Section 189 did not align in the manner that they should have, in the sense that, just like the panel of attorneys, what they should have worked together like this, so that as one takes off, the other one is de-escalating, so that you don't have any disruptions. The only thing I wanted to, yeah, please go ahead.
No, I was just confirming what you're saying, Jay.
The only thing I just want to ask is make a comment on my conclusion with regards to then the operations of the Road Accident Fund. One is that the panel of attorneys is dismissed without a recruitment and staffing plan that is going to replace the lawyers. Number two, the claims originators who are supposed to help people avoid attorneys are assigned elsewhere. Number three, there are numerous suspensions of claims administrators and so on. And that says to me, if you take the three together, you are really going to battle to process your claim. Because
Indeed,
the capacity is not there, because the capacity is compromised.
Indeed. And it did destabilize the organization from a claims perspective.
Just help us with something that we've heard from Mr. John Modise, the use of attorneys' offices for CCMA hearings. Why would something like that happen?
Chair, in some instances, the attorneys would agree that the offices of the CCMA is not conducive to hear or to convene a particular matter. The attorneys amongst themselves would then agree in terms of that either one of them would use the other's offices to facilitate the process in terms of convening the hearing. That was my understanding of that the parties would agree on a suitable venue, and consult the CCMA in terms of the venue itself being held at either of the attorney's office. So it was not uncommon, Chair.
So who would have paid for that attorney? I mean, was it something that was then offered for free, or did the Road Accident Fund be charged?
Chair, I'm not sure if we were charged. In my recollection, it would have been an arrangement between the two parties, between the two attorneys.
Right. Okay.
I haven't seen an invoice, Chair, that would detail that there was charge for the use of a boardroom to that effect.
Okay. No, we can ask the question specifically from the fund, because that's the concern that we had. Last two. On the Sunshine Hospital matter, so we had Sunshine Hospital coming to us, and we still need to work through the issues there, the rest of the issues there. But we understood that there was an investigation done, and then a whole bunch of employees, I think about 17 cases, if my recollection is correct, were then disciplined, as it were. And these were done by ER, not the managers themselves. Are you aware of that?
I'm aware of the Sunshine matter, Chairperson. I'm not aware of the number of the people implicated in the Sunshine in the hospital itself and the referral of patients to the particular hospital. The process was driven from our regional office in Menlyn, because that is where the matter originated from in terms of the relationship with Sunshine Hospital. So that is how far my understanding and the recollection of Sunshine Hospital goes from a ER perspective. It was handled by the local team at the Menlyn offices.
All right. So I must tell you, the reason I am homing in on these ER accountabilities and who's supposed to do what is because a lot of money has been spent on lawyers. I think it's about 48 million rand or even more on legal matters. And we do need to work out who is ultimately responsible. We've assisted us in terms of reviews to say it was the chief executive. But the origination of the disciplinary cases is important. Every company has got bad elements. But we've also seen a lot of cases where the road accident fund actually just doesn't conclude matters at all, and people sit at home. Somebody was on suspension, and then they simply get a letter to say, tell us why you must not be dismissed. In some of those cases, it is because it was once this committee asked about the people on suspension, and then those people got letters of, but you were gone by then, so we're not going to chase you on that. But that's very concerning about people that are sitting at home. And in cases such as, are you familiar with Ms. Mteto? I just want to understand the accountabilities there.
Chair, I know Ms. Mteto. Not on a regular basis.
No, you're aware of her in the organization.
Yes, I'm aware of her in the organization. Yes, I am, Chair.
Okay, who was her manager?
Her manager she's reported initially to Menlyn. I think she was in Polokwane, and then she was transferred to Joburg.
Yeah, I mean in the Joburg context.
And in the Joburg, yeah. And I think the manager there was Michelle Morgan and Tokozani. I can't remember Mr. Tokozani's surname. That was the senior manager in Parktown, in the Johannesburg region.
In Parktown. So when she was suspended, who would have done it?
It would have been the regional office in Parktown, the Johannesburg office.
Okay. That's
in conjunction with because it was a senior manager, in conjunction with the ER department, so we had an ER consultant in the office in Johannesburg, and he would have consulted if there was anything with the ER in the senior ER manager in her office.
Okay. Was there ever an instruction from the CEO that she and anyone who had worked with Sunshine Hospital must be suspended?
Chair, I do not know of such an instruction. What I do know is that there was a lengthy investigation around the Sunshine matter, and how it originated within the fund in its relationship with the fund.
Okay, but you're not aware of the chief executive office, the chief executive's office being directly involved in that matter?
No, I'm not aware of that, Chair.
Through ER. So Michelle Morgan would have initiated the discipline.
Quite correct, Chair.
Okay, we will get in touch with Ms. Morgan and just get her version. From my end, I think we've dealt with all the issues: PwC, direct claim staff, suspensions, use of lawyers, counsel, CCMA rulings, attorney offices, the number of staff on suspension for a long time. For now, I think I've dealt with the questions that I that I needed. Last question: Do you know a company called MNB Chartered Accountants?
No, Chair.
That conducted an investigation.
No, Chair. I'm not familiar with the company.
You're not. Okay. No. We'll ask the road accident fund. Okay. All right. I don't see any hands from members. Let me just ask if anybody has got any more hands. Okay. Final question. The NUMSA issue, one of the parties that made a submission to us was NUMSA. And it is partly from their letter that, and some of their statements publicly that I have been asking so many questions about the suspensions and so on. The reunion, obviously, you would understand why they would be concerned about those issues. Their recognition agreement was terminated, wasn't it?
Correct, Chair.
Why was it terminated? Do you know?
It was terminated, Chair. We got a legal opinion in terms of the jurisdiction that the RAF did not fall within the ambit of their particular constitution. And it was terminated on that particular basis.
Okay. Okay. When you left, where was that issue? Were they disputing it or did they leave it?
I think they were disputing it, and there was another union coming on wanting organizational rights.
All right.
But that is where we left the particular arrangement with NUMSA at that stage, Chair.
Okay.
We did send them a letter saying that in terms of the court, the legal opinion, as well as the jurisdiction of the constitution and where they could operate, it did not allow, and therefore we are terminating the agreement with the collective agreement with NUMSA. If they took that on review, I do not know, Chair. But they were terminated, yes.
Okay, and how then subsequently got organizational rights?
They were in the process of obtaining organizational rights, yes, Chair.
When you left the road accident fund?
Yeah.
Have you been in any litigation with the road accident fund at all yourself?
Chair, not. Yes, I've taken the RAF to the CCMA, where my matter was the RAF won the matter, and I'm currently taking the matter to the Labour Court.
What's the matter about? I had understood that you simply decided to leave.
Yes, Chair. The point is that there were certain commitments made in terms of during my contract relating to the Section 189 that upon termination of my contract, because I was supposed to leave during that particular consultation period, I was then asked to stay on, and hence the agreement was that I would be paid certain benefits should my contract come to an end, which the RAF reneged on subsequently. And hence I took them to the CCMA for labour practice, and I've now taken the matter to the Labour Court to see if the matter can be traversed and examined at the Labour Court.
You know, I used to think the CCMA, the Road Accident Fund, is just in the High Court. I think you guys have the Road Accident Fund has a significant number of cases at the CCMA, clearly. It's just a comment. I don't know about other organizations, but it's a staggering volume of cases for an organization that size, it appears to me.
Definitely is, Chair.
Okay, Mr. Barriel, I can't pretend I know what it's like to be the one answering questions from everybody and speaking for this long. And therefore, I shall not prolong the torture for any longer than is necessary. It is a Friday after all. And the only thing to ask you is whether you've got if there's any comments, because the committee always wants to know what would make the Road Accident Fund better. And if you have any comments in terms of our own recommendations, in terms of things that would make the interventions that would make the RAF better. It would make it operate more efficiently from a cost perspective, and in terms of employee productivity, that it really would be optimal given the volumes of work that it deals with. Is there anything that you can advise us as the committee to consider for our recommendations?
Yes, Chair. I would like to conclude to say that I think it's important that the committee looks at the staff morale. One. Right. Two, as I've alluded to earlier on, is the technology capability to really enhance that in terms of the ICMS. Three is the processing, making the process easier for the claims administration through the value chain, maybe from injury benefits to death benefits, to make that process easier. And then, obviously, Chair, is to ensure that there's proper governance in the organization. And I understand the committee's concerned around governance, which is also a concern for many in the organization. The RAF is fortunate to have a set of employees, dedicated employees, that would really like to see the transformation of the organization succeed. And I think in the last period, things have taken a little bit of a step back, but there's commitment from the employees within the RAF to see an organization that they can be proud of. And I think that want from the employees have been long overdue, and a clear path needs to be mapped out in terms of the RAF living up to its eventual potential, Chair.
No, thank you very much, Mr. Barriel. I really appreciate that. It's in the transcript. We will consider it. It's also more in line with what some of your former colleagues have stated to us by way of recommendation. So thank you for giving that some thought. If there's anything that you also want to recommend in writing, you're welcome to send an email to me via Ms. Ibrahim. Because that would help us in our recommendations. We certainly want an organization that works super efficiently, like SARS collects our money. If they can do that, then we'd be very happy. So let me thank you, sir. Let me thank you, sir, for availing yourself and for answering our questions, and for your patience with this process. We really appreciate it.
Thank you very much for the opportunity, Chairperson, and thank you to the honourable members too.
Okay, honourable members, thank you to you for your participation and your questions in this process. May you have a wonderful Friday afternoon and weekend, and we shall see each other next week. I will send a note to the members later on over the weekend, just about the next few weeks programmatically for us. The team, we've started with kind of one briefing document for the entire week. So in order to minimize the effort or to synthesize the effort on members, because members serve on multiple committees, they've got political responsibilities, and therefore the reading could I know that you're not lazy to read, but we also recognize the pressures of time and travel on all of you. So please give the Secretariat any feedback on what might assist us by way of preparation documents in order to make things simpler and the experience of the witnesses a lot more fulfilling. So thank you very much, honourable members. And Mr. Barriel, thanks again. And thank you to our colleagues from Parliament.
Thank you, Chair. Keep well. Thank you.
Thank you.
Recording stopped.
Thank you.